There's no such thing as a negative number. It's a continuum. Now, the number is 0.44 and the usual number is 0.55 or 0.66. You probably shouldn't have started me on this topic. I can see. Oh, it just irritates the hell out of me.
My name is Lara Blomfield.
I've just looked into the
Oh, okay.
about brown red.
Yes.
About putting people earlier today.
Oh, okay.
But that was
Might be able to do. Yeah, sorry.
so was there the kind of gap directly after lines, or we have a gap at 220 to 40,
Okay.
if that would be possible. This makes it that easy.
No, I absolutely understand. I mean, I don't have a witness, so it's just not. Yeah, it's just me. Sorry.
Okay.
Do I have a morning tea break between?
I'll have a
Sorry.
No, that's all right.
So
I'll have
I'm
a-
Maggie.
No, I'm Nicola.
I'm
Maggie's
Nicola.
over here.
Okay.
I'll have a look and just let the chair know that you're here.
Yes.
And if we get through, perhaps yours and Himes, maybe if we talk a bit earlier break.
Oh, yeah, no, I just was just trying to, I'm sure I've got the material here with me, but I just couldn't remember how to stretch it.
Yeah, so I think we've got you and then Himes on there.
Yes.
And then there's a break. And
Right.
there was a submitted for 20 minutes.
Right.
That's no longer.
So that's where the brown road would go?
Yeah, we could
Okay.
slot you in there rather
That
than
would,
come in.
I would probably be
Okay, I'll go and have a chat.
Hi, nice to see you. Good, thank you. I know, I'm sorry, it's going to be the Lara show this morning. No, you don't. But you're welcome to sit behind.
Bruce and Sarah.
Yes, before.
Good morning, everybody. Day 2 of week 2 of our hearings for proposed plan change 9. I've just talked with Mr. Made Apatu in terms of he started us off in the right way yesterday morning with a karakia and a formal welcome on behalf of Ngāti Kahungunu to everybody. And we've both agreed that his karakia was strong enough to see us through this week. However, if the tide changes, we'll ask Mr. Made to come back and keep us going in terms of that flow. But he's also committed to close our proceedings later this week in terms of our spiritual side. So just to acknowledge Mr. Made Apatu for joining us. We know that there was the funeral yesterday, and commiserations to the family and the whānau. But we are, the kanohi ora ko tai mai nei tēnei rā, I raro te tuanui o tēnei whare. Here we are, day 2, and a welcome to our hearing. Ms. Blunden?
No, I should have let you know, Mr. Chairman. Lara Blomfield appearing.
And you're also appearing this afternoon as well? Potentially, or maybe this morning.
It might be this morning.
If
you
that
might be
suits.
hearing a lot from me in the first hour and a half.
Fantastic.
So, good morning.
Now, just in terms of some logistics, the microphones are on all the time, so you don't need to push them on and off. You probably need to speak close to the microphone. We've received we've received your legal submissions and one of the briefs of evidence for Mr. Craig Betty, which we may have had a read. I certainly had a quick read of it last night, but you'll understand after yesterday's hearings, I've read it, but it might not have soaked in as well as it potentially should have been. So we're happy for you to go through those as you see fit. But you have some other speakers that you might want to
If I could just
introduce
introduce the people with me here this morning, Mr. Chairman. So immediately next to me is Mr. Craig Betty, who is the Director of Operations and the person who's provided a statement of evidence that you may or may not have had a chance to read. I have prepared for him a brief 3-page summary of his evidence, which I was proposing that he read, and I have hard copies here for the panel and a few spare copies for others who are interested. Immediately next to him I have Mr. Ben Rimmer, who is Tng's Technical Manager, and he is here to answer any on-the-ground operational questions that you might have, or the hearing panel might have, about Turners and Growers operations that are beyond my remit.
Thank you.
So I wonder if I might just hand up...
Oh, sorry, and to your right?
Oh, I'm sorry, to my right, this is Mr. Bruce Mackay from Hines Watties, and he and I are the next show after this one. Yes.
Welcome. We're quite happy for you to sit down.
Oh, thank you. I'm just trying to stand.
Sorry, we're not wearing funny wigs or anything.
This is much more comfortable, thank you. Would it be helpful for me to, and I will summarise the legal submissions which aren't particularly long anyway, or is that a document that the hearing panel has had a chance to read?
Yeah, we've had a quick read of it, it would have been last night, this morning, so we're happy for you to pick up on the main points that you wanted to make.
Certainly. I think it's important to note at the outset here that Turners and Growers are here. They're representing their own interests, but also that of Ends of Fruit, and that is a company that's a fully owned subsidiary of Tng, and also the grower, marketer and seller of apples grown in Tng's orchards. It owns a significant tranche of land, 740 hectares of orchards throughout Hawke's Bay. You will be hearing a bit more this morning from Mr. Betty about their orchards in Puketapu, because an issue of concern for them is the proposed raising of the minimum flow in the Tutaikuri River. They have development plans in the years to come, and they develop about 60 hectares of land into intensive apple orchards per year. And it's pretty self-evident that their ability to do that and their ability to access water to enable that orchard development to happen is potentially affected by the outcome of this plan change hearing. It is the holder of about 80 water take consents, and there is a summary of those consents attached to the evidence of Mr. Betty, which you received yesterday. Most of its orchards are irrigated using drip or sprinkler irrigations. The orchards are watered overnight, and there is live soil monitoring to ensure that the orchards only get the water that they need. You'll hear from Mr. Betty today, but he says there's not a lot of fact in their existing consents. It may become apparent to you that there are a number of water users who hold consents for much more water than they actually ever need, but that is not the case with turners and growers. At paragraph 8, I've summarised the main concerns that Tng has with the proposed plan change. The first is to do with some clauses that appear in Schedule 30, and I'll address these in slightly more detail shortly. The second is whether a water user will be able to renew a consent for a water take that hasn't been fully implemented for orchards that are still under development. And the definition of actual and reasonable might pose some challenges under that scenario. The third is to do with whether water within the interim allocation limit, which becomes available, can be reallocated. I've already mentioned the raising of the minimum flow in the Tutaikuri River. There has been a change made to the plan change to allow for 20 cubic metres of water per day to assist in the survival of horticultural crops, but there's a question of how much assistance that might be to an orchard under irrigation. And then, really circling back, the definition of actual and reasonable basically should allow for an increase in the irrigated area, provided that the quantity of water is the same as the permit being renewed. I won't deal in any particular detail with what's in paragraphs 9 and 10. Mr. Betty does address those paragraphs in the summary that he's about to give, but I will just take the hearing panel to page 3, paragraph 11, and simply to make the point that it seems to me that the clauses in the schedule that I've referred to perhaps put make the people preparing, as part of the catchment collective or preparing freshwater farm plans, provide information to the council that the council already likely has, and to identify issues that will already be apparent as a result of this plan change. So it just seems that the additional clauses there don't actually assist in the information that will be needed for those documents, given that there are a whole lot of other detailed requirements that freshwater farm plans and industry programs need to meet anyway. So I've started with that matter, but it's probably one of the less important matters. But it's just seems to be adding another layer of complexity and information that isn't really necessary. Tng have a number of orchards that are currently under development, and there are 2 examples that I've discussed with them this morning in the Puketapu area. Now, their concern is that the existing water permits that they have, which aren't being implemented to their full extent at the moment, will not be sufficient when it comes to renewal time if the definition of actual and reasonable is applied. Because even taking the maximum water use over a 10-year period isn't actually going to be the same amount as those fully developed orchards will need in the future. So there's a concern there about the ability to get consent for water that will be needed for those orchards when they're fully developed, but which hasn't been used within the 10-year period before the 2nd of May because the orchards are still being developed. So if you applied the definition of actual and reasonable, and you take the maximum water use over that 10-year period, it's still likely to be less than the orchard will need once it's been fully developed. And I know you're going to hear a lot about the definition of actual and reasonable, I'm sure, because it's troubled a number of my clients. You have and you will.
We will.
And the reason I say that is it's the interrelationship of the various clauses in that definition, which is is interesting for existing consent holders. So Clause C is another potential challenge for Tng when it has an orchard that is under development, because it refers to the area that has been irrigated. And depending on how the orchard is developed, it may be that not all of the entire orchard has in fact been developed or irrigated. So Clause C of the definition of actual and reasonable might not provide the answer that one might hope. So at paragraph 18, I say that for an orchard under development, it may be difficult for Tng to meet the requirements of Clause C, depending on whether the orchard or some part of it has been developed to the point where irrigation is necessary. That means that Tng might have to apply for consent under Tank Rule 11, even though it would not be seeking any more water than is required to irrigate the orchard, or for which the water permit had originally been granted. So I'm not sure that this is something that was actually in the minds of council officers when they were drafting this definition, and that's perhaps understandable. But I have suggested some wording at paragraph 19, which I hope will address this particular concern that I've been talking to you about today. Turners and Growers supports the reallocation of water which becomes available within the interim limit, and it does if its intended use is for primary production. So it therefore has a concern about the policy direction in 37B of the proposed plan change, which talks about avoidance of reallocation of any water which might become available. I've read the evidence of Mr. Dooney, who is the expert planning witness for Horticulture New Zealand, and I support an amendment that he proposed in his evidence and which I've set out in full at paragraph 23. And last but by no means least, the question of raising the minimum flow in the Tutaikuria River. This is a serious concern for Tng. It has 100 hectares of orchards in Puketapu, and it also plans to develop new orchards in that area. So my instructions from Turners and Growers is that with the existing minimum flow of 2,000 litres per second, there was an irrigation ban in February 2017, which was fortunately short-lived, and Tng was able to get through that irrigation ban without suffering too much harm or detriment to its orchards. But an obvious consequence of raising the minimum flow to 2,500 litres per second is that there are likely to be more irrigation bans sooner and potentially for longer. And the effects, you will hear, the effects on an orchard during a drought or a time when the apples need water of any kind of irrigation ban can be quite catastrophic. So I acknowledge here that there is the ability in Rules Tank and 8, as recommended by the reporting officers in the addendum report, for 20 cubic metres to be taken per property per day. But as you can imagine, for a property which may be 50 hectares or more, that water is simply not going to cut it when it comes to irrigating an orchard during an irrigation ban. So I've already introduced the two witnesses that I have. The first is Mr. Craig Beattie, and unless you have any questions for me now, I was proposing to have him read out his 3-page summary, which has been handed up to you this morning.
Sorry, I'm just hearing something buzzing here and I'm just turning it off. So. Right. I'm just wondering, just in terms, what we might do is we'll hear the summary and then you can tag team the questions that we may have.
Perfect.
How's that sound?
Thank you.
Unless there's any burning questions. I just had one, just in both your legal submission and the evidence, where we find parts of the plan which have been struck out and underlined. Those are your changes or the changes that have been identified by another submitter that you support? Is that right?
Yes,
Yep, okay.
that's right.
Yep, thank you. Mr. Betty?
Kia ora koutou. I thought I might just start with just a general overview of Tng before I get into any specific clauses in the proposed plan change. So Tng is New Zealand's largest pit fruit business, accounting for about 30% of New Zealand's total exports. And Enza Fruit is New Zealand's International Limited. Enza is wholly owned subsidiary of Tng within the Hawke's Bay. So we together own or lease about 740 hectares of land for apple orchards in Puketapu, Motio, Twyford, Karamu, Miani, Pakowhai, Karamu, and we also own 2 pack houses and 2 cool stores located in Whakatū with a value of about $90 million. Enza intends to reinvest in infrastructure at Whakatū to the value of approximately 20 to 40 million by 2025 to upgrade our facilities. We employ about 200 permanent employees and 900 seasonal workers in the Hawke's Bay. And we also engage third-party contractors at an annual cost of about $1 million per annum. We develop about 60 hectares of land into intensive apple orchards each year with a cost of about $12 million per annum. And this development can cost over $200,000 per hectare for the first 3 years of that development. In terms of our water use, we do practice efficient water use. All but a very small number of our orchards are irrigated overnight using drip and sprinkler irrigation. And we use external consultant advice, who advises us when to irrigate. We also have soil moisture probes in all our orchards. I suppose, unfortunately, the threat of an irrigation ban can drive poor behaviour when managing orchard irrigation, which can lead to growers to use soil as a water storage medium and effectively over-irrigate in the hope that crops can cope with an extended dry period. In terms of resource consents, we hold over 80 water consents for irrigation and frost protection, and all but one of those consents are groundwater takes. So, as Lara said, these consents are vital to sustain our orchard investments, and we have little or no fat in the existing consents, which would enable us to develop further orchards without obtaining new water permits for that development. So in terms of some of the specific clauses in the proposed plan change, I'll take us through those. So Tng does support a recommended new Section C in Schedule 30, but opposes new clauses 1 and 2 on the first page of that schedule because they are redundant, we believe. The focus should be on good or best of farm management practices regardless of the state of water quality in the catchment, and only the Hawke's Bay Regional Council has access to modelled or monitored water quality data. Number 8, Policy 36F. We are not clear as if the amended clause would apply to a consented take which has not been fully implemented. For example, a consent to irrigate an orchard under development. Our concern is that this policy and Rules Tank 911 might take away consented but as yet unused water when the consent holder applies to renew or replace that existing consent. The next one that is important for us is Policy 37D2. The hearing report recommended no change to this policy, but recommended the definition of actual and reasonable refer to the average annual amount as measured by accurate water meter data in the 10 years preceding May 2020. The use of average would have been very problematic for us, so I support reverting back to the maximum annual amount as measured by accurate water meter data in the 10 years preceding the 2nd of May 2020. Policy 37B and 38, we sought changes to these policies to enable water which became available within the interim allocation limit to be reallocated if its intended use was primary production or it would be used for stream flow maintenance. Accordingly, I support the change to Policy 37B recommended by Mr. Dooney. Policies 39, 40 and 41, Tng supports the changes recommended to Policy 39 in the hearing report. Policy 43 and Schedule 31, Policy 43 and Schedule 31 propose to raise the minimum flow in the Tutaikuri River from 2,000 litres to 2,500 litres per second. TNG's concern is that the increased minimum flow might result in irrigation bans which are longer than 1 or 2 days, which has happened in the past. If this was the case, it would have a detrimental impact on our 100 hectares of orchards in Puketapu. Policy 47B, TNG supports the hearing reports, recommended change to this policy. 51, 52, Tanks Rule 7 and 8. TNG supports the addendum report recommendation to change rules Tank 7 and Tank and 8 to allow lawful takes existing at the 2nd of May 2020 to continue to take up to 20 cubic metres per property per day. Rule Tank 5, TNG supports the hearings report's recommended change to Tank 5 and Schedule 29. As Lara said, in terms of definition of actual and reasonable, we sought an amendment to this definition to allow for an increase in the irrigated area provided that the quantity of water applied for was no more than the permit due for renewal. If an applicant is not seeking to take any more water than had been allocated under the permit due for renewal, the over-allocation of water will not be increased if that renewal consent is granted. This will enable some ongoing orchard expansion, which is critical in this catchment area for TNG. Accordingly, TNG requests that clauses C, 1 and 2 of the definition be further amended to read as follows. Clause 1, sorry, take that as read. Okay, so in conclusion, the orchards that Enzo owns and leases are dependent on a secure supply of water. There is considerable potential for further orchards to be established within the area affected by the plan change, but the terms of the plan change would make it very difficult, if not impossible, to get consent for new water takes needed to establish and operate the orchards. We have a plan to develop 11 hectares this year in that area and another 40 hectares in the next 2 years in that catchment area. TNG is very concerned about the Tutaikuri minimum flow being increased. This would impact on TNG's plan to develop further orchards in the Puketapu area. If there is an irrigation ban, the permitted activity rule allowing lawful takes existing at the 2nd of May 2020 to continue to take up 20 cubic metres per property per day will not, that will not be enough water to irrigate a growing crop and is highly unlikely to be sufficient for rootstock survival.
Thank you.
Thank you. I should also say, members of the hearing panel, that there is some evidence to come from Dr. Daverin later this morning for Heinz Watties, and that evidence in respect of raising the minimum flow is adopted by TNG.
Okay.
Thank you. Any
Thank you.
questions?
Any questions? We'll start down the end.
Your paragraph 3, Mr. Betty, you talk about the development 60 hectares of land each year. So is that resulting in a net increase in total area of land under orchards, or is there land being retired as well?
Part of that development will be land that we will redevelop from existing varieties, but the majority of that will be new land that we were looking to develop. We have an expansion program for one of our varieties called Envy, which we intend to grow another 5 million TCEs over the next 5 years.
And the source of water for irrigating that new land, how do you plan that in advance? In terms of you already got consented water for that?
We haven't got consent of water, we'll be applying for consent.
Yeah, part of our due diligence is actually to look at the availability of water on those blocks of land we're selecting moving forward. Looking back at the Tūtaikuri example, Pukitap area, we looked at the 10 years history prior to signing leases in that area.
So it's not necessarily
New water take. Is that what-
water that's consented, or the consents are owned by Turners and Growers or Enzel, it's owned by some landowner, some other landowner, is that
Yeah.
right?
Yeah, that's correct. So we have both own property and lease property, so a lot of, a number of those hectares could be leased property that already has consented.
So it's the consent holder rather than TNG that has to deal with the issues or the potential issues under Plan Change 9 in terms of water availability, various schedules that they may have to adhere to.
No, I don't believe so.
No.
I think we normally take over
You
the
do,
water
Yeah.
consent.
you have the consent transferred to your name?
Yeah,
Okay.
absolutely.
Give that
Yeah,
back.
sorry, yeah, we have the consent transferred across to us. I think Craig referenced the 80 consents that we own, so that's that would be transferred across, and we follow that process through.
So those 80 consents in paragraph 6, that you are the consent holder in those?
Correct.
Okay. And you say that most of those are groundwater takes. Do you know if they're hydraulically connected with surface water, those takes, or are they deeper groundwater takes?
It's a combination. I mean, we farm out Hamoana, Twyford, so there's a combination that we work. Generally, it's, groundwater take.
Yeah, sure.
So just following up on that, you talk about the potentially increased flow in the Tutukuri. How many of those groundwater takes are hydraulically connected to the Tutukuri of the 80 or so that are listed there?
No, I can't answer that, sorry, no.
Yeah,
You know the answer.
I don't know the answer to that, so.
What about Ebbets? Or those
Yeah.
bay blocks? They're
Yeah, they're going to be
hydraulically
the same
connected.
as the other current architect, aren't they?
Yeah.
So they would be really close to where we're currently growing, so I would assume at this stage that they're linked, yes.
So how many approximately? Are we talking about 2? Are we talking about 10?
Hectares?
Hectares.
No,
Consents.
2 orchards, 10 orchards that would be with an existing groundwater bore that is hydraulically linked to the Tutukuri or proposed to be hydraulically linked to the Tutukuri. Because
Yeah, there's three
from what I
currently-
can see,
there's three
most of them are
currently
some way,
consented to,
most of the ones at Puketapu are some way away from the river,
Yes,
like Motio Road, for instance. I can't recollect that being very close to the river.
So you've got Mayhew Road. Where else?
it's Bay Trust and Ebbets, isn't it?
Which is right next to.
Yeah. I mean, so the 11 hectares is right next to Bay Trust, so there might actually even be the same water source. So it might only be this additional.
That's this year's.
Yeah, yeah.
So look, the 11 hectares that we're developing this year is right next door to the existing orchard,
Sorry,
Bay Trust.
can you speak into the microphone?
Yeah, the
Okay.
11 hectares that we're developing this year is adjacent to the existing orchard, Bay Trust.
And the further one is adjacent to the Ebbets
And the,
planting as well.
yeah, and the further one, the 40 hectares is adjacent to the Ebbets planting that's existing in Puketapu.
So we're talking about 2 orchards potentially.
Yeah.
Yeah.
Okay, thank you.
I had another question in relation to your paragraph 7 on industry programs. And I think it's the last comment you make about only the regional council has access to modelled or monitored water quality data. I mean, surely that data is, the council makes that data available to consent holders, land users.
Yes, that's correct.
Okay, thank you.
Mr. Betty, can I just ask, you've provided this long list of consents held. How many of those are being fully exercised, if you like? Are a number still relating to proposed development, or do they all relate to existing development?
They all relate to existing development. But they'll
So-
be different, they could be at different stages of development, however.
And they're all relating to orchards, the two at Anderson's Road and Wakatū, like one or two of them are obviously discharge permits at Wakatū. But all the others are orchard takes for orchards, have I got that right? Thank you.
Correct.
Thank you.
Yeah, I have one almost simple dumb boy question. It's around your main thesis, which seems to be about securing long-term supply of water. And what I'm interested in is getting a feel for what is the main thing you want to get out of Plan Change 9 that will give you confidence that there will be this long-term secure supply of water?
You want me to answer that? The main changes that would give that security to T&G are changes to the definition of actual and reasonable to allow for an increase in irrigated area. And then, so that's one, and then the other main concern is around those consents which might not have been fully implemented, and that would require some changes to Policy 36F and Policy 37D. And then, of course, when it comes to irrigation bans, there's the concern about the raising of the minimum flow in Tutaikuri, because of a fear that there will be loss of water at key dry periods when irrigation is most needed.
Am I right in assuming that those concerns would be similarly felt by other growers?
I am sure that's the case, and certainly, yes, I expect many growers have those concerns. They may not have the same expansion desire that T&G has, but they will want to be able to, they want to have certainty that they will have water in the future to grow the crops that they want to grow, or to grow slightly different crops on the same land.
So does water in the future mean an endless supply, or is there a sort of limit's not the right word, but a sort of more defined notion of how much you think you might need in the future? Is it asking too much to try to look ahead that far?
I guess growers don't, well, some growers will have very good ideas about how much water it is that they need. But what most growers, I think, will ask you for is a workable definition of actual and reasonable that accounts for the change to the maximum water use over the 10-year period prior to 2 May 2020 is a massive improvement, and that's supported by T&G and Heinz Watties, and I'm sure many others. So that's fantastic. Average water use over that 10-year period was problematic. But the concern is for growers who haven't yet used what will be their maximum use for their planned development. And they may be slightly hamstrung by that definition, and that's a concern. Because although it's possible to get a resource consent for more than actual and reasonable use, the way the policy direction is going in the plan change, it looks like it's going to be pretty difficult, and that's the fear that growers have.
Yeah, what I think I hear you saying is that the design of the plan mitigates your ability to plan ahead too far.
I think that's right. The way the plan changes at the moment, I think if the outcome is that if the plan change remains in much the same form as it currently is, I think T&G will be looking very hard at whether it can continue to
stays
develop
in business.
in the future. It won't be exercising its expansion plans that it has in mind right now, because how can you develop 60 hectares of orchards if you can't get water for it?
Okay. Good, thanks very much.
Thank you.
Is there anything that prevents turners and growers transferring consents from one property to another?
It does have to.
I mean, certainly the plan change does allow for that. Well, the plan does, and the plan change too. And my recollection is that it would be a controlled activity if certain conditions are met.
I think it is.
The question might be whether there is also a change in land use associated with that, at which point I think the activity status might change to discretionary. But certainly it is potentially possible if the standards, terms and conditions of those rules are met.
So a take from the Karamu catchment could be transferred into the Nararoro catchment, for instance, without barriers to transfer, as I would understand it.
I thought it had to be in the same catchment, but
Yeah,
sorry.
I think you might be right.
I'm
It's
just-
all right, I can check it, but it is an option.
Yes, it does. So the Rule 62A, that's RRMP Rule 62A, which seems to be the rule that applies to transfers within these catchments. It's a controlled activity provided that the permit's within the same catchment and to a point downstream of the location to which the permit relates. So there are some quite strict conditions there that would need to be met, including that the transfer does not result in an increase in nitrogen loss. So there would obviously have to be some comparisons done between the property from which the permit was being transferred and the property to which it is being transferred. And as I understand it, if those conditions aren't met, then we default to 62B, which is discretionary.
Thank you.
Yes. Yes, and the other point that's just been made to me is that, I mean, basically that involves taking water away from an existing user, obviously, or transferring it from an existing user for use in an orchard. And there's also a condition about in fully or over allocated water quantity areas, the transfer can only be for the part of the permit for which is actual and reasonable use. So that might, although the transfer is technically possible, whether or not that's going to be enough water remains to be seen, because it's delimited by the definition of actual and reasonable at its existing site.
Can I just follow on from that? The definition of actual and reasonable would it not preclude you from? I was just looking at your appendix with all your consented takes, Mr. Beattie, and would the definition of actual and reasonable, would it preclude any of that water being taken and put into some form of storage? I mean, do those takes and the rates of takes specified there, do they go straight onto the orchard, so to speak, or is there some form of storage prior to it being used?
We don't have any storage
No.
for water.
And under the definition that you couldn't put it into storage with your existing, using your existing consents, is that right? I mean, you've got a weekly volume here. Is that for a certain number of weeks of the year, or is that?
Well, so
with the monitoring we referenced early on, we water when it's recommended by a consultant. So no, it's not used the whole year round, only during the times when it's proven we need to put more water on.
Do your consents currently have any constraints about how often you can take that amount of weekly allocation?
There's just a maximum weekly take, I believe, isn't it? So we work hard not to exceed that.
Yes, very.
Yeah, very hard.
Do they have annual volume constraints as well?
I believe they do. I think they do, yeah.
Yes.
Sorry, I don't have a copy of
No,
one.
we don't have a copy of that, but yes, we think they do. They have a weekly limit and,
Litres per second,
yeah.
volume per week.
Sorry, I can't hear you.
So we have currently we have these maximum litres per second and total litres per week, but we also think there's an annual cap as well.
It's the weekly one.
Thank you. I just had a couple of questions. I'm just wanting to understand, you mentioned the water ban that's occurred, and I was just interested in the effects of the ban over all of the orchards that you either own or lease. I'm assuming that the effects of those would be different across that portfolio of orchards, or would they be equally affected by the ban?
Yeah, no, very different due to the different soil types.
Yes.
We're predominantly drip irrigation, so once the soil profile dries out, it's very difficult to re-moisten that soil. So, and I believe when that ban was in, we had the 50 hectares in place in that area. So it is a real challenge to recharge the soil after a ban.
My next question is mostly related to this policy 37. We'll go back to the original brief that everyone's here. 36F, and this is in regards to issue of having consents, and you may not have used all of the water that's been allocated, and there are some development plans that haven't yet been realised, and I'm just trying to, it seems a little bit like a Trojan horse to me, and you can argue that point that it seems to me a fair argument that you haven't yet developed that area and you haven't used that water within that time period of the consent. That makes sense, but how do you discern between what's a bona fide development plan and what's a brand new consent for a new land use? That's the part that I'm struggling with. If you could elucidate me, that would be great.
Well, that, I think, in terms of the proposed wording that's been put forward by T&G, I think that question can be answered by the changes that are proposed to the definition of actual and reasonable. And I suppose, I mean, as I sit there and look at the wording that I've proposed for subclause 2, it would require an applicant to demonstrate that the area can be irrigated effectively, and that wording was proposed there to cover a situation where they couldn't say that the area had been irrigated in the past because the orchard, that part of the development hasn't occurred, but they would need to prove that that can happen in the future. And I suppose that wording doesn't actually address your Trojan horse argument, because how is the council going to know whether this is a brand new development or not, except perhaps to say that presumably the T&G would have an existing consent which would have contemplated the irrigation of the entire orchard. I mean, I imagine that's how they work, and you can help me if I'm wrong here.
Yeah, that's
there's a
where I'm
risk
going to, is
associated.
where the consent clearly says that this is the intention, not only to take this amount of volume for this particular purpose over this area of land, then that seems quite clear to me, but it's where it doesn't. Where it may not have been intended, but so, for instance, T&G or any other applicant may have had development plans, but they're not included in the consent for whatever particular reason.
I'm just trying
then
to
the council would treat it as a brand new consent.
Well, yes, they might.
Yeah.
So I suppose that means, yes, I mean, the consent ideally would obviously have a clear description of the complete area of land to be irrigated, which would include not only the current development but the planned future development. But sometimes that doesn't always happen, and if that doesn't happen, then there's a real battle for T&G there to persuade the council that actually that's what had been intended, even though on the face of the permit that's not what it says. And I suppose it would have to work back through irrigation volumes and things like that to persuade the council that what the permit says might not quite reflect what was meant or needed. But nobody wants to have that discussion or battle later
Yeah,
in the
because
future.
obviously there's some logistics. There's a large number of orchards and
Yes.
consents there, so the logistical challenge could be considerable. And so I'm just exploring that a bit further about how that would actually work in practice.
What if you've got an existing consent? Give us a, it would be it would cover the whole area, including an orchard. Like if we're developing an orchard now, we've got consent to
Got a
irrigate the whole
consent
thing.
for that block of land, and then,
Okay.
yeah, so, yeah, and if we were redeveloping it, we would still just be getting consent for that block of land, so.
No, I understand that, but yeah.
Look, I've just conferred, and the belief here is that for orchards under development, the consents are for the entire block of land or blocks of land that are intended to be developed. So that means that at consent renewal time, the consent on its face should reflect that, and then the discussion that needs to be had with the council is an explanation of why not all of that irrigated area has in fact been irrigated and why not all of that water has in fact been used, and that is because this is stage 2 of a 3-stage orchard development on this property. I think in terms of logistics that's how it would work.
Okay.
But the definition of actual and reasonable is problematic if it's only 50% of the way through that development, because that cap at maximum water use is going to effectively prevent redevelopment of the other 50% of that block.
Okay. I'll probably have some further questions for the council in that regard, but we can leave it for there.
Thank
Do we
you.
have any other questions? No. Thank you very much.
Thank you.
Thank you.
I am, yes. We're next.
So Ms Blimfield, you're on again,
I know.
and we'll just make sure we've got all the papers in front of us. We've got the legal submissions, evidence of Mr Mackay, Mr Daverin, who's appearing for at least a couple of the parties that we're aware of, and just those 3, is that right?
That's right. So you should have 2 statements of evidence from Dr Daverin.
Yeah.
So the one we were given today is different from the one in his expert evidence.
Yes.
Is that correct?
Yes, it just deals with the issue of the raising of the minimum flow.
Great. Yep, we've got that one as well.
Okay, you've got a copy of your... Right, yep, both. Yeah.
you want to approach this in a similar vein to our last presentation, in terms of you want to cover the key points in your legal submissions, or?
Yes, but I'll try and be punchier this time.
Okay.
So I've already introduced Mr. Bruce Mackay this morning. To his right is Dr. Anthony Daveron.
Good morning and welcome.
So those are the two witnesses that Heinz Watties will be calling. I have to acknowledge right at the outset that a number of the issues raised in the May statement of evidence from Dr. Daveron have actually been addressed in the addendum report.
Yes.
And that's been helpful, and almost without exception, those changes have been positive. And the changes are supported for the reasons that are set out in Dr. Daveron's initial evidence, and I've given you the paragraph references at paragraph 6. I will just explain why you are receiving late-breaking evidence on the raising of the minimum flow in the Tutaikuri River, and I apologise for that. The reason that that has happened is because it was only as a result of discussions with a representative from T&G that Dr. Daveron became aware of the fact that there had been an irrigation ban back in 2017, February 2017, when the minimum flow in that river was set at 2,000 litres per second. Because this was not apparent when Dr. Daveron had prepared his initial statement of evidence, because he'd done an analysis of the mean daily flow record from some archived flow data on the Hawke's Bay Regional Council's website. And based on those records, he'd actually reached a conclusion that there had been no ban days over that period, and there wouldn't have been any ban days over that period, even if the minimum flow had been raised to 2,500 litres per second. And it's as a result of the fact of this February 2017 irrigation ban has led to the discovery that some raw telemetered data is used to determine when the minimum flow has been reached, but that data is different from the data that Dr. Daveron had analysed. So I accept that this is new evidence and it's come late in the piece, but it was really only because discussions with T&G had identified this as a potential issue. So at paragraph 10, I've identified what I have described as the live issues from Heinz Watties' perspective. The company has reservations about the 90 million cubic interim, if I got that right, interim allocation limit. Like T&G, it has a concern that policy 37 doesn't allow water within that limit to be reallocated, although of course transfer is possible if conditions are met. There is a concern from Heinz Watties' perspective about the definition of actual and reasonable and its limit to the maximum annual take over a 10-year period, particularly for a business like Heinz Watties, where water volumes are driven by the quantity of produce being processed in its factory. So it is difficult for somebody like Heinz Watties to use water more efficiently. And if, as I go on to say, if volumes in the factory increase, then so will the amount of water needed. And reference to an historical maximum may not be enough. You'll hear from Mr. Mackay this morning. He has also concerns about the plan changes presumption about the cause of stream flow depletion and whether there's been adequate investigation of that. He also has concerns about the plan change and whether it makes clear provision for the utilisation of stored water. At paragraph 11, I've just described the high level of uncertainty amongst a number of submitters, I believe, about how the interim allocation limit was derived. It's apparently been based on modelled data, but it seems that for for the 2012 and 2013 year, but in other years, modelled water use has been much, much lower than the figure of 90, which has been set as the interim limit. There is a concern too about the sinking lid approach that's being taken in this plan change. So basically, the plan actively discourages the reallocation of water that becomes available within the interim groundwater limit through its use of the word avoid in policy 37B until there's been a review of the allocation limits. But there's not a great deal of certainty for plan users about exactly when that review must be completed or will be completed. I think there's a date for when it might be started, but that could be many, many years away. Mr Mackay notes in his evidence that there are thousands of hectares of prime horticultural land in these catchments that have no irrigation consent now and very little prospect of getting one, given the current wording of policy 37B. I think too, and I can't really claim credit for this observation, if an existing water take can be transferred, and certainly the plan does allow for it in RRMP 62A and B, then why does it also, in the next breath, direct the council to avoid reallocation of water within the interim limit? Those two positions seem to me to be slightly inconsistent. And as I say, the idea isn't mine. I've pinched it from Ms Gillian Holmes, who's a witness for Horticulture New Zealand, and she makes the point that from a hydrological perspective, there's no difference between the transfer of an existing consent and the reallocation of water which might become available within the interim allocation limit. So my submission is that the plan change could soften its approach in respect of the reallocation of water within that limit, especially if its intended use is primary production. Heinz Watties also supports the change to 37B, which has been suggested by Mr Dooney, that's Horticulture New Zealand's planning witness. I did, when I was looking at the transfer rules, note that there does seem to be a slight problem with Rule 62A in the RRMP. And this is just a technical matter which I'm sure council officers will be able to fix. One of the standards, conditions and terms includes a condition which requires that the transfer does not result in an increase in nitrogen loss exceeding the amount specified in Table 2 and Schedule 29. But that table's actually been deleted from the plan change, so that provision doesn't now work. And there is a relatively easy fix, I think, and Dr Daverin can address you on that this morning. At paragraph 22, I acknowledge the changes that have been made to the definition of actual and reasonable use, but they have the effect of capping Heinz Watties at the maximum water use at its two factories over the 10-year period before May 2020. And I've set out there the context, so just to give you some understanding of the existing consented volume that Heinz Watties has for those factories, that's at paragraph 22, subparagraph A. And its maximum water use, which comes in over that 10-year period at just over half of that amount. As Mr Mackay's evidence has indicated, Heinz Watties has become an increasingly efficient user of water, and that its water use per tonne of finished goods is decreasing, but its overall water use is increasing because it's got greater volumes of produce coming through its factory. So there are other factors too that can drive water use at factories, and an example given is a wet harvest means that you need much more water for washing fruit and vegetables. So this is not something that can be addressed by being an efficient user of water, it just is the situation. And capping at renewal time the amount that Heinz Watties can take to the maximum amount over that historical 10-year period is going to be problematic if there is more produce coming through the factory that will require more water. So the reality is that at renewal time, Heinz Wattie's is likely to ask for less than its currently consented volume, but more than the maximum over the 10-year period. And that's going to require discretionary activity consent, and that, of course, is theoretically possible, it's not prohibited, but all of the trends and the policy direction and the indication given in this plan change is that it's going to be a real battle for a consent holder to get more than that actual and reasonable use, determined by that definition. And that's the reason why Heinz Wattie supports a change that has been proposed by Mr. Drury, who is the expert planning witness for Hastings District Council. So he suggested some wording changes to policy 37D, which uses the actual and reasonable assessment as a starting point only, rather than simply an application of that across the board. And his proposed wording allows for a volume beyond the actual and reasonable amount, taking into account a number of reasons, including why the proposed volume is needed, the efficiency of use, and what the actual proposed use is for, and whether it's for beverage, food, fibre production, etc. And finally, the value of the investment associated with that volume. And here, that's where the value of the investment that Heinz Wattie's has made into its two existing factories would be a factor that would be taken into account. So that's the softening that I'm proposing. Dr. Daverin's supplementary statement of evidence addresses the raising of the minimum flow. I don't really need to say more about that. You will hear more from Mr. Mackay when he gives the summary of his evidence about his concerns in relation to stream flow depletion and the lack of clarity he says that is in the plan change about how the stored water might actually reach water users. And the final concern is to do with the land use change provisions. So there have been some changes made to Schedule 29, and those are generally thought to be an improvement. But there are still some problems that have been identified from Heinz Wattie's perspective with Table 1 and Schedule 29. Now you might remember that's the table that identifies activities according to their nitrogen leaching risk. And initially the table had any irrigation of unirrigated land was identified as the highest nitrogen leaching risk, which didn't seem to make sense. And that's now been changed to note that it is a variable leaching risk, and that's fair enough. But there are still problems with the hierarchy in terms of the activities listed as the highest through to the lower nitrogen leaching risk. And you will hear a little bit more from Mr. Mackay about that when he gives the summary of his evidence.
Thank you.
So I have copies of, I'm sorry, I should have handed these up earlier. I reduced to writing the summaries. Bruce.
Good morning, Mr. Chairman and Commissioners. Thank you for the opportunity to speak here today. And I believe you've read the evidence that we submitted during the weekend, so I'll not spend time going through that document. Rather, I'd like to speak to what I feel are the underlying issues that may impact Heinz Waddy's business if the most recent version of the proposed plan change recommended by the council officers is brought into effect. I am supportive of much of the proposed plan change in principle, but feel some of the detail and the nuance in the detail does not satisfy the demands of a long-term plan change. I was a Tank Collaborative Group member who attended every meeting and most of the workshops over the 8 years the project's been in process. The draft plan change that determined at the conclusion of those meetings which clauses that were either agreed by all of the attendees or disagreements were noted was significantly different to the document that we're discussing today. I will address the 5 significant issues that Heinz Waddies have. Those issues are allocation limits and as they relate to actual and reasonable use, surface flow augmentation, land use change, utilisation of stored water and future focus. First, I wish to also try and convey some of the sentiment and feeling of many of our suppliers. Most, including myself, are somewhat intimidated by proceedings such as this and are reluctant to attend. There is some nervousness when we come to these hearings, not so much for what we have identified, but rather for what we may have missed in the now 237-page document. My primary concern is that this plan change is not future-focused. It appears to have focused on one issue, that of over-allocation. In doing so, the authors have written policy that will stagnate or repress primary production in Hawke's Bay. Policy that states no groundwater consents will be issued and that replacement consents be no more than the highest recorded use in the 10 preceding years allows little opportunity for increasing production on the existing 6,000 hectares of unirrigated land in these catchments. Consent durations of only 15 years will come around quickly, and if you're unfortunate enough to encounter 10 wetter seasons, or the dry season was the season your land was in pasture or maize, well, tough luck, that's what you're going to get. It offers no opportunity for growth. The pet food expansion project opened last week at Timona wouldn't be possible as the anticipated 370,000 cubic metres of water required would not have been allocated. We're always looking for opportunity to increase production. We're investigating another opportunity for substantial off-season production. Using average water use per tonne of finished goods values, we would need another 175,000 cubic metres of water to allow this. That proposal that we're looking at would be a net improvement to the Hawke's Bay GDP of about $120 million annually. Again, this proposed plan would make it very difficult to get consent for this new water. The allocation limit comes only at the expense of industry and irrigators, not municipal or domestic use, not even at the expense of anticipated future municipal or domestic use. These water users who take approximately 31% of all water and waste 4 to 6% of that through leaky networks are not required to experience the same sort of restriction industry and irrigators do. Why are they not required to install rainwater collection or report metered water use or be allocated the highest measured water use in the 10 previous years? This allocation, I'll talk about that later. This allocation limit also assumes an allocation limit of 90 million cubic metres. This is a modelled value, and the trouble with models is they multiply errors. If a number of assumptions are just a little bit out, the errors, they don't add, they multiply. And by the time you have a result, the potential variance is huge. The reality must be measured, and it's not until substantial and accurate data is available limits like this will always be nothing more than fiction. And I do note in the plan that they bring in guidelines, policy 36, looking at the effects of groundwater abstraction, saltwater intrusion or reducing groundwater table levels. But the last and most important of my concerns regards the future of the water resource management in Hawke's Bay. The answer, in my opinion, is storage, and policy 56 correctly identifies the benefits that will accrue. Parts of the plan change regarding storage are good: where you can store water, when you can harvest water, how much you can harvest. However, reticulation and utilisation of that stored water are not. I believe the most efficient and beneficial manner that stored water could be reticulated and utilised is by release back into the stream or river network, thereafter allowing that water to enter the aquifer system through existing networks, or perhaps artificial recharge, also allowed in this proposed plan. Then water users can utilise by taking from groundwater using existing infrastructure. The benefits are ecological, and this will occur at times of low flow when the river ecology is at greatest need. Economic, in that the large water storage infrastructure will be more cost effective, most likely located in lower value, less versatile land, and no piping or other physical reticulation would be required. While I believe the intent to allow a process similar to this may be in the policy and planners' minds, it appears to me they are predisposed to only releasing water from storage to augment surface water flows. This is apparent both from the blanket ban on issuing new groundwater consents, which would be necessary both to take the groundwater, but also consents required to change land use, which I've previously discussed. Further to this, I'd like to discuss behaviour. When proposals such as this are presented, consent holders have to make decisions. Most decisions are made well in advance of the season: what to grow, when to plant, who to supply, and so on. Those decisions are currently based on knowledge, skills, available resources, pricing, relationships, and other factors. When you add what may be a scarce water resource and no obvious opportunity to mitigate that scarcity, the decisions will change. Water use will be prioritised. High-value crops will be favoured over low-value crops, and unfortunately, we as processors tend to have the lower-value crops, which also happen to represent the majority of domestic table food. Lower value because we have to compete in the global, somewhat commoditised marketplace, but necessary not just to consumers as we provide food on the supermarket shelves the other 10 months of the year. It's not fresh or readily at hand. But also to the growers, where we provide cropping opportunities to spread growing risk and protect soil and plant health with effective crop rotations. Water use for irrigation is a prerequisite for growing processed crops. Every crop intake into our factory comes off an irrigated orchard or paddock. Growers will not chance growing without it, so decisions to grow our crops that will allow our factories to continue to contribute possibly 25% to the regional GDP and 1.5% of national GDP are depending on positive outcomes from this plan change.
Thank you, Mr. McLean. We'll hear our last presentation and ask questions. Mr. David.
I've got two pieces of a summary of my primary evidence and
The 1.5 pager.
and some further evidence that was produced regarding the Tūtaukiri minimum flow. Four key issues that I'm going to raise here that I've pulled out of my evidence is the interim allocation limit, the transfer of water take consents or permits, actual and reasonable, back on that subject again, and the nitrogen loss thresholds. In terms of the interim allocation limit, it is an interim allocation. The concern I have is, with this particularly as an expert, is that the review of this is going to start sometime in the next 10 years, which is a rather uncertain period of time for which this could occur. If it is such an important limit that is going to govern the direction of the plan, then I would have thought that there would have been moves afoot to have this underway now. It's not a difficult process, and it should be done much sooner than 10 years, within a period of 10 years. You've heard about the transfer of water permits. I support the transfer of water permits to another location in the same aquifer or on the same stem of a surface take. We need to remember that any groundwater take, for example, is already included in the interim limit. It is already part of the environment. The effects already exist, and therefore that consent and permit should be able to be transferred to a new location so long as it meets the conditions for the area and in terms of nitrogen loss. Our council has already talked about the fact that Table 2 in Schedule 29 doesn't exist. It's been struck out, and I would suggest that the wording around this should read something like, the transfer doesn't result in an increase in nitrogen loss, which is rather broad and not very definitive, but I would adopt something along the lines, so long as it's not greater than 10%, as they've recommended, as has been recommended by the council officers. The use of average water use, actual and reasonable. The average water use is now the maximum, and I support that. What I don't support is that there is a limit on the number of years of record that you can use. This is not the only regional council that has gone down this path, and we've had several battles over this, and it has been agreed elsewhere that any water metadata that meets some quality requirements should be used. And that's not just historic, but it's also future water use. So somebody that, for a consent that is coming up for renewal in the future, then you should be able to use the data, all the data that you have, to determine what your consent limits should be. I do have a concern that a piece of work that's been done by the council and I apologise if I get the pronunciation of this wrong, by Kuzniak, deals only with rainfall, and that is, when it comes to irrigation demand, is not a very sound process to take, because irrigation demand is not just driven by a low rainfall for a season. It's about the distribution of that rainfall during an irrigation season, and the soil type and the crops that are being grown, and therefore irrigation demand is the answer to determining the seasons that you should be looking at in terms for particularly the 95th percentile. I'd like to just touch on Schedule 29 and Tank 6. I'm pleased to see that there have been some amendments to Tank 6 so that they did not inadvertently capture land use change. I strongly feel that Schedule 29 is one of the most subjective pieces of subjective tables I've ever seen, and it will only become a litigious exercise when you're dealing with changes in land use. What is needed, and it's pleasing to see that one of the recommendations is that a land use change can't increase in-loss by more than 10%. Now that's great, but what it's also missing is a little bit of teeth, because you need to be able to specify a period when you might determine what your existing land use in-loss might be, so that you can then then determine whether or not you're going to get an increase of more than 10% when you change land use. So I support a threshold. Is 10% the right number? Given the uncertainties of overseer, it might be a little bit on the low side, but I do not support the retention of table 29, schedule 29 and table 1. Do you want me to move now to the further evidence that was presented?
Yes,
for the
please.
Te Tai Kuri? Let me just bring that up. As our council described, this came about because a couple of things. I went to update the Te Tai Kuri daily mean daily record to sort of complete the 2020-21 season when I was preparing, finalising my evidence. And the data that I downloaded had a whole series of spikes in it. And I requested from the regional council whether or not those spikes were real, because from a hydrologist they looked very unusual, and was assured that once the data was processed, it would change. And it certainly did change. And so I then was alerted by Turners and Growers that in fact there had been a ban in 2017, February 2017, and it lasted 3 days, 22nd to 24th of February, which did not appear in the flow record that I had analysed. And even if you go to the environmental flow record that is on the Hawke's Bay Regional Council system, the flow during that period was almost 3 times the minimum flow. So I'm not sure how the decision was made for that minimum flow to occur, and for me it provides growers with a great deal of uncertainty going forward. If the minimum flow is to be raised to 2,500 litres a second, for me there's uncertainty that is unreasonable from a management point of view, that with the data that's being provided for that, and I couldn't support that rate on that basis, could not support any longer the raising of the minimum flow to 2,500. Sorry for the short synopsis.
Let's open it up for questions.
So this extra evidence on the Te Tai Kuri, the figure you've got at the back in your Appendix 1 figure, so that's data you obtained from the regional council, is that correct? And
Appendix 1?
yes, the chart in Appendix 1.
Yes, that I just downloaded that off the website and thought, hello, sorry, the scales disappeared off the side.
Yeah, well, that was one question.
But the dashed red line is the 2,500 litres a second minimum flow.
And it's an unusual looking
Yeah, it's
hydrograph.
Oh, yeah.
I don't know what you've done to it, but can you...
Oh, I've done nothing to it. That's the data that's the raw telemetered data that came off the website.
Yeah, no, I think that... Oh, we won't go into that. Can you just confirm with me that the data you obtained was mean daily flow data?
No, this is instantaneous data.
Instantaneous.
This is 15-minute data. Yep. And I was simply going to take this data, calculate the mean daily flow, and update my records to complete my evidence.
I can't recall, does the minimum flows, when they kick in terms of affecting abstractions, are they based on mean daily flow?
That's my understanding, and there's some... no, my understanding from speaking to Turners and Growers, and through them a grower, that it's based on the instantaneous flow being reached.
Okay, well, we might have to confirm that with
Yeah,
council staff at some stage. Just another, I guess, question about allocation, groundwater allocation limits, 90 million cubic metres versus something else less. I guess, in my mind, I'm trying to get my head around, well, what is it, if, regardless of what that figure is, the actual figure is, if groundwater levels are falling, does it really matter what that allocation limit is except for planning purposes? Whether it's actually 90 or actually 76 million cubic metres, if the groundwater levels are shown to be falling, there's still a problem that has to be addressed.
in some years that will be the case. These are alluvial aquifers. This is an alluvial aquifer, pretty much the same as we have in most eastern parts of New Zealand, all through Canterbury, the Wairau Plains, Waimea Plains, and they the water levels are very dependent upon your recharge that you get. In this case, you've got a relatively high recharge from the river of 4,000 odd litres a second. That is pretty constant. That comes in, and what will really change your water levels on a year-on basis is the degree of land surface recharge that arrives. Getting a bit outside my evidence here a little bit, but I do have a concern that for example, over the confined aquifer area in the model, in the groundwater model, no land surface recharge is considered in the modelling, and I don't know why, other than the fact that it was considered that there was upward pressure that would stop water getting to the aquifer, and that there was a semi-permeable layer that would stop it getting to the aquifer. Well, I don't accept that. Semi-permeable means that water can get to the aquifer, and to remove that from the determination of the allocation limit is a worry.
Assuming that recharge stays the same, or well, let's say that just stays the same going into the future, but there is the demand for water increases, then surely groundwater levels will continue to drop, and hydraulically connected surface waters may continue to carry less flow at critical times of the year.
You set aside the hydraulically connected water because they're going to be governed by minimum flows, and they are already governed by minimum flows. So the groundwater levels that we're talking about are the semi-confined and the confined aquifers, which are very dependent upon your year-by-year recharge. And I mean, the general groundwater thinking is that eventually they will, so long as there isn't huge increases in takes, we'll reach a new equilibrium.
Okay. Just one question, Mr. Mackay, in relation to the production, the operations in your factories with the use of water. Is there much recycling of water undertaken, or is there potential for that?
Yes.
Is there more potential for that?
We're always exploring it because all of our water comes at a cost, and not just for the obtaining the water, but for any discharge. So the water, all the water that we use, eventually will end up in trade waste, which we have to pay for. Yes, we run 3 water networks through our factory. We have potable water, we have recycled water, and we have stormwater. And those 3 networks are separate. So a lot of our water use is governed, as Ms Blomfeld said, that there are seasonal impacts, but we're also governed by requirements in our food safety certification, as are other food producers. A wet season requires more vegetable or fruit washing. A very hot season, a lot more water for hydro cooling. Crop volumes change and so on and so forth. But if we take a reasonably constant metric of water used per tonne of finished goods, that has dropped from, I think, 11.7 or 11.8% since 2012. We're very, very conscious about how much we use and how we use it. Can I speak to your question that you just had of Mr Daverin? Sure. Just regarding the impact of the 90 million cubes and the measured metrics of what impact that's having will be on soil water tables or groundwater levels and potentially saltwater intrusion. So if we are abstracting too much water, over time we will see the trends in those things going the wrong way. In the tank meetings that I attended, we were told that the current level of abstraction, which was modelled at 90 million cubes, there was no evidence of that and that those levels were sustainable long term. That was a report that Dr Smith presented to one of the tank meetings. The opportunity for increased water use clearly has to come from somewhere else, so that will be stored water. If we do look for growth, we can't, we're recognising that we can't take it from groundwater. We have to take it from somewhere else, and the obvious opportunity, as identified in Policy 56, is stored water. And we need to, I look to the plan change or the proposed plan change to allow opportunity to use stored water to either increase production, to, as they state there, to supplement shortages or shortfalls in allocation, which I also read as being able to counter seasonal variance. Some seasons you'll see from the data I presented, the volumes that we use on an annual basis fluctuate a lot. And I can't tell you, we need to allow for the maximum potential demand, which is well covered in our 8.9 million cube consent, but our actual use at 4.5 and our peak over 10 years. It may be 4.8, 4.9 next year, and at what stage we turn around and say, yes, I want access to another 300,000 cubic metres of water. I've allowed for it from storage. I just need to get it from storage to the factory or to either of the factories to be able to utilise it. So I've heard yesterday and I've heard today everybody say we're special, we want it, we need it more than everybody else, and that's where my concerns about future focus come from. Everybody is special, but not just the water users. There's the ecology is our primary concern. The social and the cultural implications of the water, that's absolutely imperative as well. But the economic performance, regional councils charged with maintaining that, as well as the ecology of the water resource. So that's what I'm referring to with future focus. I just want to see in the plan change an ability for a business such as ours, or the growers who support us, to go and say, yes, my consent is now highest recorded in the 10 previous years, but if there is some situation that requires that I need more water? Is it a dry season, or am I going into a larger paddock, for example, or whatever? We need some mitigation or some mechanism whereby we can get access to that water, and be that storage, be it whatever. The other, that's my perception. The other point that I have made there is this supply. Everybody seems to be fixated on getting water from groundwater. There's also demand, and to me this plan change very much focuses on irrigators and industrial users. I see very little in there for municipal takers of water, the municipal supply. They're taking 31% of the water, of all of the consented, of all of the actual use, thereabouts. They're leaking 5 or 6% of it, and yet they don't have to suffer any of the restrictions that industrial or irrigators are deemed to want to take. I also note that municipal water users in Hastings and Napier are some of the more wasteful water users than any other water users in the rest of the country. And perhaps it's because they've had access to such an unfettered supply of really good water for such a long time. Those values, if you look at average, this is off the Water New Zealand website, average water use per head of population in New Zealand at about 225 litres per day. In Hastings it's 288, and in Napier it's 288, and in Hastings it's 350 litres per person per day. So wouldn't it be great if we even got back to the average of New Zealand water users? All of that water which is consumed could be available for other use or to leave in the environment. That's just, we can affect supply, we can affect demand. And to me, irrigators and industrial users have been, well, they're the easy cabs off the rank. They're the ones that are being regulated. They're the ones that are being monitored and looked at, but nobody's questioning the other 31%.
Thank you, Mr. Mackay. Let's see if there's any further questions.
No, thank you for those comments.
Just a few questions for Dr. Daverin, please. In your supplementary evidence, or your summary evidence, I should say, last paragraph on the first page, you say an individual user may have a use pattern that's not typical of climate data. Can you give me examples of that?
Off the top of my head, no.
I couldn't think of any either.
Generally, the daily water balance models are based on pastoral use. And with some corrections for arable or some other uses. I can't think of one particularly off the top of my head. Yeah.
Second question, you've got a number of clients who would provide telemated water use data.
Yes.
Telemetry systems aren't 100% reliable, are they?
The ones that I've dealt with have been, there's no gaps in any of the data.
So a remote sensing site, say at the Tutukuri, is likely to have occasional failures in data transcription to the regional council, and isn't that the most likely cause of those apparent spikes? The spikes in the record? Correct.
No, that's a measured flow.
No, it's not a measured flow, it's a measured water level
That's been converted to a flow.
instantaneously.
Yes,
So if the data's wrong, if the telemetry systems had some sort of glitch in it, then that would show a higher flow or a higher water level.
if there was a failure in the transmission, we would have a gap. So we wouldn't have a 15-minute value.
What I'm saying is certainly my experience of telemetry systems is sometimes they have garbage in, garbage out. And having worked in a regional council for 12 years and having seen some of those, if you like, false alarms about very high or very low water levels due to transmission glitches, if you like, it's not uncommon.
Yeah, I don't consider the data that's here a transmission glitch. There may be something wrong at the monitoring site with the water level recording of the water level. But the data's been transmitted. And generally, if there is a transmission glitch, there will be a data logger on site that will have, because all you're doing with this data is you're sending it out from a data logger through a modem back to site. That's been pretty standard practice for a long time with telemetry systems, so that you've always got a backup on site of the data. So I guess if there's a gap in the record, you can go and get it. But to me, these are glitches in the stage record, which is then converted to a flow.
Yeah, I guess my experience with water level recorders is sometimes they can get stuff in them that gives false records in particular.
I would agree with that, given my years at Water and Soil Division.
I'm going to table 1 in...
What I would say though, it depends, I mean, if you're going to use this data though to determine whether a minimum flow is going to be imposed, and then it gets processed at a later date, and that doesn't occur, then a minimum flow might be imposed when it should not have been imposed.
So I don't understand your concerns about Table 1 in Schedule 29. Like, to me it just looks, it's an indicative, the way I read it is an indicative table that shows relative leaching rates, and if you're changing from a low leaching activity to a potentially higher leaching activity, say from sheep beef to dairy or arable, you have to do an assessment of the relative nitrogen leaching loss. That's all I read into the table.
Yeah, my concern will be how that is implemented at a consenting level, because the subjectivity then allows a consents officer, for example, to say, well, you're jumping from a low risk to a higher risk, when in fact, if the soil type is different, or particularly the soil type where you move climatically, there may be no risk at all, and then it becomes, having been involved in these sorts of things, then it becomes a litigious operation. And for that to be based on a subjective assessment, and it is just a subjective table, because some of those may not be higher risk than the other, than one above it, is of concern, particularly when it starts to be used as part of the consenting or the renewal of consents, or the applications for consents. If you've got some numbers that you can deal with, then it doesn't matter what your land use is. If you can demonstrate that you do not exceed those limits, then it becomes a controlled activity. And that is for me, is a far simpler process than having to deal with a table that's highly subjective.
I guess it seems to me that a lot more sensible than the original table 1.
Oh, I would agree with that.
And so the council's got to have some means of assessing the impacts of a land use change and whether an assessment by a, say, overseer to that change in land use is necessary. What alternative have you got to something like this?
Oh, I agree that they've got to have something, and I think they've gone part of that way. I think by suggesting that to stay in that, like, as I read it, to stay in that controlled activity path, that if you can demonstrate that you do not increase your in-loss by more than 10% from your current land use activity, then you can stay in that path and move through the controlled activity. Otherwise, it becomes a discretionary activity.
So what's the alternative? Nothing?
Sorry?
What's the alternative? Have nothing?
Oh, that is the alternative. You've got a number you can work with.
Okay.
It's not based on something that says you're moving from sheep and beef to commercial vegetables, so therefore you are a greater risk to the environment.
Correct.
Because as long as you can demonstrate that you are not making that more than 10%, if that's the number that gets settled on, then you stay in that activity path. I support that.
That's not what you say in your evidence.
Oh, yes, I do. I say that I support
The 10% threshold that you say, Schedule 29, okay, Schedule 9 deals with,
I'm talking about the table, but that is subjective, and I don't support the table. I support the notion that is the proposal, the recommendation that, and you can keep your increase below 10%, then you stay in that controlled activity path.
so you say just stick with the 10% and eliminate the table.
Yeah.
Thank you. Final question. Are you familiar with Irrikelk?
Yes?
Do you believe it overestimates irrigation demand generally?
Yes.
Thank you. By what sort of order of?
Sort of depends upon your soil type and your land use, but anything from about 10 to 15%
Sorry?
anything from about 10 to 15%.
Thank you.
And it will vary seasonal to season.
Okay, thank you. Do you have any questions?
Not for me, thank you.
I just had just a couple of clarifications. Just at paragraph 10 of your evidence, Mr. Davern, just in terms of you've quoted from Smith, the 90 million cubic metres a year limit in reference to the Section 32 report. Are you accepting those figures, or are you just stating that as?
No, I'm just stating those figures.
Okay. Just going down to 12, and this also came up in the legal submissions about the review period, that you consider it's too long. Did you have a suggestion on what that should be?
Oh, for the 90 million cubic metres?
Yes.
I think if it's more than 5 years, it's too long. If it can't be done within 5 years, then throw some more resources at it. I mean, I understand one of the great difficulties with this is going to be the paucity of accurate water metadata, because to get your an inherent part of getting the allocation limit right is to know exactly what's being used. And at the moment, it's very much a modelled activity because there aren't enough really good water meter records around to determine what actual use has been or is.
Thank you. We didn't have any further questions. Thank you very much for your presentation.
Thank you.
In terms of our timetable, we're going to take a break now for about 10 minutes. And then we've got Mr. Apple. Hopkins is in the back. We had talked about potentially of bringing Rorick Ag further, closer in, but we're actually within our timetable at the moment, so. Okay, so maybe there might be some coordination just to find the right time. So we're just going to take a break for 10 minutes. We'll see you back at 11 o'clock. Thank you. And Mr Gardner
Yes,
Hopkins, good
yes.
to see you again.
Good morning. I know most people have sat to address the panel. It's my preference to stand if that's acceptable.
Oh, as long as we can hear you, and we can, that's fine.
Yes, excellent. And so look, I think the panel should have two documents. One is my legal submissions.
Yes.
And the other is the PowerPoint that Mr Hill will be talking to.
Great.
Which will get up on the screen when it's his turn. Just in terms of timekeeping, I think we had 40 minutes allocated. We're running a little bit behind time. But if possible, we'd still like to aim to be around that 35 to 40 minute mark.
Yes, that was the time provided, yes.
Thank you. And what my intention is to try and focus what I talk to in the legal submissions. You've heard aspects of what I address from other counsel, and I don't want to unnecessarily repeat things. But there's a few things that I'd like to take the panel through, hopefully taking 10 to 15 minutes, and then the balance of the time on the evidence itself that Mr Hill will talk to through the PowerPoint.
Thank you.
So look, I won't take the panel through my introduction, other than simply to note in terms of the scope of these legal submissions that they are relatively focused in terms of the role or the case for Mr Apple. It is very much supporting the wider case that is to be presented by Horticulture New Zealand. It is a member of the board. It supports the evidence that's already been filed by Hort NZ, and it does intend to adopt the submissions that you will hear later from Hort NZ. So it's very much a focused presentation here today. So the first element that I do wish to address the panel on is this somewhat vexed issue of giving effect to the NPS FM 2020, which popped into the mix partway through the process. And as I say and understand, the panel's heard a bit about this already, so I'll just summarise what I think the legal position is. I think it's very clear that the panel has a duty or a requirement to give effect to the NPS FM 20. It's an issue of how it can do that within the scope of Change 9. And essentially, my submission is, if the NPS FM 2020 can be given effect to through Change 9 within its scope, then it must be given effect to. And that really is the very simple proposition. If it can be amended to give effect to the NPS FM 2020, then those amendments need to be made. Otherwise, the statutory requirement to give effect to will not be met. Very briefly, and I don't think it's in these written submissions, but in terms of the scope or the jurisdiction for the panel to make various changes, I take a slightly different view to Mr Robinson, who I think suggested to you yesterday that a general submission saying amend the plan change so that it is consistent or gives effect to the NPS FM, I think he said that wasn't enough and that you needed some specificity in terms of the submission.
And the relief sought, yes.
Yes. Now I take a slightly more generous view that if a submission is cast in general terms and does say give effect to the NPS FM 2020, make amendments in order to give effect to that planning instrument, then that does provide wide jurisdiction for this panel to make the necessary amendments. It's not uncommon for submissions to be cast in fairly wide terms, and in terms of what that means in the detail, that's a matter of understanding the evidence, understanding what is necessary to give effect to the NPS FM 2020. And really that's what I want to jump to, because one of the key policies in the NPS FM 2020 is policy 11. So I'm at paragraph 17 of my submissions, and that there is freshwater is allocated and used efficiently. All existing over-allocation is phased out, and future over-allocation is avoided. And my submission is this is a key policy that drives your decision-making in terms of allocation and addressing over-allocation and preventing future over-allocation. And there's quite a lot in that policy. There's essentially 3 elements, and all are important, and that policy has to be read carefully in terms of understanding what it means or what needs to be done to give effect to that policy. And I've referred there in some of the subsequent paragraphs to the defined terms that are used in that policy. I won't take the panel through those, but jumping to my paragraph 20, which is where I try and pull some of the key threads out from the policy. Firstly, over-allocation is a particular state of degradation or a trend towards that state for an FMU, and you must be satisfied on the evidence before you that this prerequisite exists before intervening to phase out existing and avoid future over-allocation. So my submission, that's an evidential matter. Mr. Apple isn't putting evidence itself forward on that issue, but you do have evidence on the extent to which there is degradation and therefore the extent to which there is over-allocation in terms of the NPS FM 2020 definition. The second point I make at paragraph B, in terms of policy 11, there is no time frame given in the policy for the phasing out of over-allocation. And it doesn't say as soon as practicable. It doesn't give a particular urgency. And while the NPS FM 2020, I think, is to be implemented by 2024, even at that point in time, there's no suggestion that over-allocation needs to be sorted at that point. So my submission is that means that the timing of any measures that this panel adopts through Change 9 must be proportionate, taking into account all relevant considerations, including economic well-being under Section 5, as well as efficiency under Section 7B. And then my point C, and this is really where sort of some of the rubber hits the road, the avoid directive in policy 11 only takes operative effect once any over-allocation is phased out. So once over-allocation has been phased out, it is only at that point that there is effectively a policy to prohibit further consents to avoid future over-allocation. So as I said, there are almost 3 steps or 3 key elements embedded in that policy. And returning to the first one, allocation and use, in terms of efficiency, efficiency isn't defined in the NPS FM 2020, but there is a provision that refers to the efficient allocation of water as including economic, technical, and dynamic efficiency. In other words, this isn't just about reducing water use. It is about using water more efficiently, more productively, and potentially for greater economic benefit or greater benefit to the community. Not entirely sure what dynamic efficiency means. I think it's something of a term of art for economists, but there's an element there that...
Oh, please don't tell me you're an economist.
not this time.
Thank you.
But my 21, so pulling all of this together, my submission is that policy 11 actually is not necessarily as directive as some submitters may suggest. And I think some people see the word avoid and they jump automatically to, that's a hard sort of prohibition, that's a king's salmon, avoid means not allow, give effect to means implement, you must do this. My submission is that there's actually some discretion in how the Plan Change 9 implements that policy and its elements. And the Avoid Directive kicks in at the last stage of that implementation.
Just so I'm clear, what you're putting forward is that in terms of Policy 11 for the MPSFM 2020, are you suggesting that those three matters that need to be implemented are sequential? Or are you just saying that there's no time limit in terms of
yes.
Those regards?
I'm suggesting that in part they are sequential. So the first part in terms of allocation and efficient use, my submission is that is a general matter to be implemented or to be achieved, and that informs how over-allocation is phased out.
Okay.
And I do say that is the first step, and then the second step in terms of the sequence is once over-allocation is phased out, then future over-allocation is prohibited.
Okay, thank you.
In my written submissions, I address the actual and reasonable use issue. I think perhaps the panel has heard a fair amount on this, and I'm happy to really have this section taken as read. I don't think I say anything particularly new in that section that hasn't been said before or won't be said again. Under my heading, Joint and Global Management and Transfers, this is I think a particularly important issue in terms of the mechanics or the workability of Change 9 going forward, particularly for some of the larger users of water, like Mr. Apple. And you will hear how they manage many orchards in sort of blocks or groups, and that some of their existing consents allow effectively the operator to manage where they apply water and when. In an obvious example, one orchard might be in a stage of replanting, and so might need more water than other orchards being managed in the group. And really the need and the wish is for Change 9 to ensure that that sort of group management can be consented going forward. And I do think that's what Rule 11 is intended to achieve. And it does use the phrase joint or global in terms of its text. And so I think that's the sort of, if you like, pooling of existing consents in a renewal into one new consent to allow that sort of management to occur. I'm not entirely sure Rule 11 cracks it, or at least there are some question marks as to how that would be applied in practice. And so I've raised a few questions in my submissions about that. I've suggested that it might be helpful if officers could provide some worked examples of how this rule might be applied in practice. And that might either demonstrate there's some issues with the rule, or it might give some comfort that this rule actually will achieve what I think it is intended to do. The other concern, though, is if Tank Rule 11 can't be achieved, then that tips you into Tank Rule 12, which is a prohibited status. And the submission for Mr. Apple is, particularly in light of my submission on Policy 11 of the MPSFM, that actually non-complying status with the strong policy framework behind it is an appropriate planning mechanism that would still give effect to Policy 11 of the NPSFM 2020. I think the issue of transfers in and of themselves is a little more straightforward, and I think the rules provide a clearer pathway for that. Possibly gets complicated if, as part of a global consent application, there's a transfer and a change of use, and the intention to have this sort of global management approach. So those are some of the perhaps more subtle issues in practice. And then very briefly, root protection. I think there's now clarity as to the intent of a particular permitted activity rule, rules 7 and 8. While it's a measure of protection, the very strong submission, and I think the clear evidence, if you need it from Mr. Apple and others, is it's helpful, but it's not a panacea, and it really, if the allocation issues, if the action and reasonable use issues aren't resolved sufficiently, then the root protection will not be the ambulance at the bottom of the cliff in terms of long-term economic viability for the types of operations that Mr. Apple and others have. So look, that was about 15 minutes, I think. So it was really all I wanted to say from a legal perspective. I'm happy to take any questions now or get into the evidence and, if need be, wrap up with questions at the end.
I just had one question, just coming back to the scope of the MPSFM 2020 and the submissions, and you referred to those of low corporation in terms of their view regards that needed to be quite specific in the submission, the relief sought. And I'm just wanting to interpolate here with you that is it your view that you still require the relief sought, but that would be done in terms of hearing all the evidence and submissions from the submitter, including the original submission?
Yes. So the original submission
Yes.
is the starting point
Yes.
for jurisdictional scope. And my submission is if there is a general submission that says give effect to the relevant superior planning instruments, give effect to the relevant national policy statements, then whilst that is very generic, that is enough to ground jurisdiction to then look at a relevant planning instrument, NPS, and then give effect to it.
Did you have a view, this is a slight nuance, there are a number of matters in the MPSFM 2020 that relate to once an FMU has been established, then there's a task list of a number of things that the Regional Council has to do, including changes to its plans. Would you accept that in the absence of that FMU process having been undertaken, it's difficult to then implement a sort of pick and mix after the FMU has been established if there hasn't been one in this particular plan change?
Correct. There are some practical issues as to what extent the NPSFM can be given effect to, for example, in the absence of identification of FMUs.
Yeah.
My submission is that every effort should still be made to give effect to those parts of the MPSFM that can be given effect to. But if there are clearly matters that can't, then there is this question, then does Change 9 give effect to the MPSFM 2020? My submission is if it is clear that an element of the MPSFM 2020 can be parked and dealt with later, then Change 9 would not offend the requirement to give effect to the MPSFM 2020. So if there's like the FMU issues, if they can be identified as something that is effectively outside of the scope of Change 9, because that work on FMUs hasn't been done and can't reasonably be incorporated, then those elements of the NPSFM can be put to one side, but the balance, or what can be implemented or given effect to, must be.
And did I hear you correctly also that there would be consideration of those matters which may frustrate the implementation of those, or giving effect to NPSFM in future plan changes?
I'm not sure if I referred to frustration, but certainly if there was an element of Change 9 that was considered to cut across the future implementation of the NPSFM, then that would be difficult, because it would then risk being contrary to the requirement to give effect to it.
Thank you.
Just a question about the NPSFM. If I read sections 3.2 to 3.4 in particular, there are some quite onerous process requirements that relate to the region, so-called, like every regional council must engage with communities in tangata whenua to determine how to municipalise, applies to water bodies and freshwater ecosystems in the region. And then 3.3, every regional council must develop long-term visions for fresh water in its region and include those in the regional policy statement. And 3.4 also talks about fresh water, no, not to the same extent. Given that we're only dealing with part of the region, and given that those process requirements haven't been met, if you like, during this process, not in terms of the region, what impediment does that present to us in implementing the NPSFM?
Yes. So my submission on that is, I suppose, drives from the general proposition that a requirement to do the whole can include the requirement to do part of the whole, or to achieve the whole in parts. And so whilst it's expressed as the region, my submission is that those obligations could be advanced in part of the region, and that Change 9 could be considered as a step towards implementation or giving effect to the NPSFM in the part of the region that it relates to. Now that can of course only go so far, because all of the required steps are not being met, but I think it would probably be fair to say that the thrust of what the NPSFM 2020 envisages for the region, Change 9 goes some way within part of the region to achieve aspects of those steps. And so my submission is adoption of Change 9 on that basis would not run counter to the requirement to give effect to the NPSFM 2020. You could say it's a step towards giving effect to it, or it's partial giving effect to it. And it can only go so far because of the scope and the nature of the process.
Okay. We might hear from Mr. Hill now.
Excellent. I'll hand over.
Good morning, everyone. As it says, I'm Richard Hill from Mr. Apple. I'm the Chief Operating Officer for the orchards there, and that's a position I've held for over 30 years. And during that time, my main role has been to develop the orchards and manage them with what started as 7 individual orchards and is now a fully integrated apple producing business. And we've gone from something like less than 500,000 cartons 30 years ago, when we were the largest apple grower in New Zealand, to still being the largest apple grower and producing ourselves about 4 million cartons. I did hear Turners and Growers say that they were also the largest. It depends.
Everyone's large and special.
Our word is largest producing, in that we produce a lot of apples ourselves, 4 million cartons, and we're responsible for marketing and packing just over 5 million cartons. So we're the largest in terms of production of our own fruit. That's what that's saying. We're employing over 2,200 people. Labour is really a limiting factor to expanding the business. And we operate 15 orchard sectors throughout the district. 10 of those are on the Heretaunga Plains, where we're talking today, Napier, Hastings, Havelock North, and 5 are on the Ruataniwha Plains in central Hawke's Bay. And right now we're about 1,284 net planted hectares, with those sectors ranging in size from 60 to 120 hectares. The largest one is at one location, but a lot of the other sectors have several locations, and we've got about 58 separate orchards to make up that area. Having said that, you can see we grow on a whole range of soil types right throughout the district, from very light to very heavy, and that obviously influences our management from a water point of view. And I'll just note there that we also have 3 pack houses and 3 major cool stores and a head office export division. I mention this because we're a significant contributor to the labour in the district and the wages, and we've estimated something like $30 million worth of wages go out to the district through our business. And we're also a 50% shareholder in Profruit Juice Factory. Irrigation. Irrigation management is very precise now, and it is influenced by the variety, the tree size, the rootstock, the growing system, the crop load, the soil type. It is a very detailed business. And a point I'd like to make is that in our increase in production over the last 30 years, a lot of that is obviously due to increased area, but a significant part is also due to increased production and yield. And I want to refer to yield later because it does influence a lot of things that happen. And some of our varieties over the last 10 years, we've increased the yield up to 50% of what we used to do. And that has quite a big effect on how we irrigate. We do irrigate all varieties separately because that's obviously quite a key thing. And we've moved in terms of water efficiency over those periods very significantly from used to be high volume hand shift pipes and travelling irrigators where we're looking to irrigate 100% of the ground area to now we're virtually all targeted irrigation of the root zones with under tree sprinklers and drippers. So we're using less water than we used to.
Water efficiency.
I guess we can see that water is going to be a limited resource in the future. We're sort of reaching that stage now with no new consents being done, and it just pays to be efficient and do the best you can with what you've got.
Thank you.
And so if I look at the strategy for irrigation, we obviously irrigate different varieties quite significantly differently. And if I give you an example, I take a variety like Pink Lady, which is a relatively vigorous tree, a naturally large fruit size, and its quality is measured in terms of bricks or sugar levels. We don't put much water on that variety because it grows well, we don't need big size, and we want high sugar levels. And then I compare that with a variety like Jazz, which is naturally small, and they want big ones. It's easy to get good sugar levels, and it's a relatively weak tree. We tend to irrigate that a lot more. So it is quite precise in those sort of aspects between varieties. We are focused on, as I say, on maximising the yield and the quality, and our market plan can be quite different for different varieties, which will alter their water use and the inputs to make them perform. All our orchards have neutron probes for measuring irrigation, and they're strategically placed on all the orchards to account for the different soil types and the different varieties. And they're very useful in making sure we're we're maximising the use of our water. In general, we're measuring the neutron probes weekly on the orchards, sometimes more frequently in key periods, and those probes are telling us how much water's in the profile. And between measurements, we can see how much water's been used and whereabouts in the profile it has come from, down to a metre. And that really does influence how much water you put on and for how long you water, because we're really trying to target the root zone and not put water on that's not going to the root zone that won't be used efficiently. A couple of key points that I mentioned before was yields, and high yields are important to the viability of a business, and water management is key. As we've increased the yields on our orchards, you have to be much more precise with the inputs to maintain that performance. And you know, when I say that we've got varieties that are yielding like Jazz 50% higher than it did 10 years ago, water management needs to be much more precise. High yielding trees are much more sensitive to drought stress than low yielding ones. And I can think of 20 years ago when we almost got by in a lot of seasons without irrigating. But we could not do that now when we're talking 6,000 cartons a hectare and not 3, and we're talking about climate change and different situations. I mean, I note, for example, the last 2 summers, from an orcharding point of view, have probably been the driest 2 in the last 30 years. And so we've had to get very precise on how we do that. So yield is a very key part of it. In terms of what are the 3 things that are really important to us to manage the business is security of supply, flexibility of use, and maintenance of volume. And we've learnt when we don't have security of supply, in other words, or we've had issues where valves have stuck or sprinklers have jammed, that in high yielding sensitive varieties, you can really lose the crop quality and yield within 2 or 3 weeks. And we've unfortunately experienced that at times when systems have broken down and we haven't picked it up quick enough. So we know the significance of issues when you don't have enough water. And from a financial point of view, we're spending about $10 per export carton to harvest on growing a crop of apples. And if you get to that stage, you have to harvest the crop whether it's worth something or not, because you need to get the fruit off the trees. To have lost that $10 a carton, which we're talking $40,000 a hectare, is just real significant. Without security of supply and those things, you wouldn't take the risk the next year. We've learnt that very quickly at the high yields and the sort of climate we're now experiencing, you get sunburn, you get smaller fruit, you get problems, and the fruit can easily be lost. But also more important is that when the tree's under pressure like that, that has an effect on next year's crop as well. So where we have lost crops through lack of water, where things haven't worked to our extent, the next year has been a very difficult, disastrous year as well. It's more than a one year issue. The other point I mentioned, which goes to just show how important the water is to us now, and the utilisation of it, is that we're now redeveloping our orchards, as most people are, to take out big trees and grow lots more small trees. And that's to get better labour efficiency and to get better yield efficiency. And so we're targeting higher yields, and our new blocks are getting better yields than our older blocks. And when I look at Mr. Apple's performance, our average yield is about 1,000 cartons per hectare above the national average. And our new blocks are above that as well. And so we are targeting yield, and which adds to the cost of the business and the risk. And one thing we are doing with the smaller trees is they're much more labour efficient and yield efficient, but they are much more subject to drought stress. Smaller tree has a smaller root ball, less root run, is just much more sensitive to drying out and needs to be irrigated more effectively, more efficiently, and certainly more frequently. And I say up there, high yields and smaller trees are critical for improved efficiency and financial performance. I mean, in this business, we need to continue to get better to stay where we are. The other point that's key to Mr. Apple is that our 15 orchard groups, we run as one large orchard. We think of it as one large orchard to gain the best efficiency out of it. And it's particularly a change from the old days where each orchard could operate on its own account. We now do labour and variety mix and a whole range of things as if it was one big orchard. So we grow the right variety in the best area, and we're trying to grow bigger blocks of the same variety to get more efficiency in terms of labour and spraying and all the rest of the things. And we tend to grow the varieties where they're best suited. So some of our orchards are significantly more frosty than others, so we're going to grow the varieties there that are less frost sensitive. You know, if I keep referring to Jazz, but it is a variety that's very frost sensitive, so we'd rather grow that where frost is less of an issue. And so that does mean to gain those efficiencies for labour and variety mix and just orchard efficiencies is very important. And water has to be managed on that same basis, you know. We talk about security of supply, but being able to utilise that to best advantage is important as well. And why I say that is we're in the process now, for example, of redeveloping, and we're wanting big blocks of the same variety. So we might have an orchard, as we have got, that we're pulling out a large area on that orchard, but the orchard alongside we're not taking anything out at all, and we need to be able to move the water around to best utilisation to be able to get the best out of it. Where we can, we've amalgamated consents to give that flexibility and efficiency to water use. Very important. So I'd be the first to say that, you know, we really do support the tank process and what's led on to Plan Change 9, but I guess it comes down to the detail, the devil's in the detail. And we're really keen to make sure that there's not detail there that stops us managing our business to best efficiency. And, you know, moving consents and expansion of that is very critical. We do have some hold-ups to that process, and we need to make sure that there's rationale behind that, or we need to make the changes. Where irrigation does become limited, and we've had that in a few situations where we're related to low flows in water in rivers, we need to get good advance notice of that, and the suggestion is stages of reduction rather than a switch on and a switch off of the system, because we really do need to plan and organise that to best advantage and least losses. And of course, base amounts left to keep trees alive, not validity but viability should be the word up there, I see, is very important. Historically, our company's grown a whole range of different things from grapes to stone fruit, kiwi fruits and vegetables. They've all got different watering needs, different timings, and grown in different areas. And having flexibility of that water use is really key, because who knows the future? About a third of the apple area we currently grow on was grapes at one stage. And what it'll be in 20 years' time, with climate change and market preferences and that, we don't really know, but we need to make sure that we don't limit the potential uses of that land and our business. So we need flexibility till we know what the future is. In summary, without the security of water supply, and I'd say flexibility of water use and maintenance of water volume, we could not risk taking our business into the future. I mean, we accept that water is a limiting factor like labourers, and we're doing our best to get the best utilisation out of that water. And I guess one of the things, having lived in this area for a long time, I could give the example of when I was a youngster, the house I lived in, the water was provided under pressure from the well, and we had a shower and a bath, and everything was good. By the time I was a teenager, in the summer, there was no water in the house, and we put in a pump to pump water to that house from the same well. And now that I'm more experienced and older, we've now put another well in, and we've now got a 6-metre dropper on that same house. And to have arbitrarily set a limit of where we should have stopped taking water out of the aquifer could really have been set at any of those particular times as we've gone through that whole process. And I think also of another example of one of our orchards that we purchased out at Meani about 25 years ago, had overhead sprinklers run by the well pressure out of the ground, believe it or not. And we ran 40 acres with a tap running overhead sprinklers with water pressure out of the ground. The water pressure there is still positive in the season, unlike the house example, but we now don't use those overhead sprinklers. We've got a pump, and we actually use under-tree sprinklers targeted to use the water more efficiently. And I guess we want to get the best utilisation we can out of this aquifer, and it is hard to know where the limit of it is, because we've gone through quite a process, and we're still going through that same process. And so I'm very cautious about where the limit is. We certainly know there's some risks about what we do, and we have to be careful of that, but I wouldn't like to arbitrarily set a limit that we found in 20 years' time we could have actually exceeded. And so I guess I'm happy where we've got to so far, but we have got a limit on putting out more consents, and we need to be very careful about how we manage that water resource. Now, I have got detailed evidence which I can hand out, which backs up the points I've talked about there. So I can make that available to the panel as well, but happy to take any questions.
Thank you. Thank you. I was almost going to say thank you, Mr. Apple. Thank you, Mr. Hill. I enjoyed the presentation because it was informative, just to really explain your business and your experience in the area was really helpful. And there was a few terms that I wasn't familiar with, but I know my colleagues may be more familiar with apple growing than I am of apple eating. We'll see if we've got any questions.
I've got one question, and it might be covered in your supplementary evidence or what you're going to table. How do these global consents work? Will you have, in, say, 10 blocks, you've obviously got contiguous or close blocks of orchards, is that?
Yes, I mean, there's several examples. You might have one orchard with 3 different wells on the one orchard, and we combine the consents on those 3 wells on that orchard. Or we have got a situation where we've got orchards that are a few hundred metres apart, and got wells on each orchard, and we're combining the consents between the 2 orchards. So that if we decide to redevelop one and not the other, we've got a shortage of water on one and ample on the other, which are the things we're trying to do to get efficiency in terms of production and performance. We want to make sure we can utilise the water to best advantage.
So when you say global, you're not talking about a wide number of orchards over different areas. It's more closely associated blocks with bores that you use to transfer water, if you like, within those contiguous blocks as needed or as necessary.
Yeah, yes, that's right. I would go so far as to say we would like to see it expanded where there's rationale and reasonableness to do it, and you obviously have to, if the water's coming out of the same bucket or the same aquifer and the stream depletion and all those other things have been taken care of, that happens as well, because that is the trend in the business. To maintain performance, we sort of have to move with the times, as it were.
Okay, thank you.
I just had a question in regards to, this was pretty much your last slide, and just talk about historically you've grown grapes, stone fruit, kiwi fruit and vegetables, and at the present time you're focused on apples. Do you have any plans or intentions to diversify from apples back into some of those other fruits and vegetables?
No, right now, no. No, I mean, we're not expanding the business as we sit here now. We're improving performance to get more fruit, but off the same area.
Right. Thank you. Any other questions?
Yeah, I just want a bit of clarification here. I'm not sure I quite understand what an orchard sector is, an orchard group. Could you just clarify that for me?
An orchard when I say 15 orchard sectors, we have 15 orchard managers running orchards, and some of those sectors are just one big orchard, and some might be 5 orchards in close proximity under the one sector.
But are they all growing apples?
They're all growing apples.
All right.
Yes. Yep.
And I was curious about the word yield. I think you answered most of my questions because I wasn't quite sure what I wasn't clear in my mind whether yield just simply meant getting more
apples per hectare.
And how you're going to do that. So, and I think the answer, or part of the answer you provided me with was get more smaller trees and less bigger ones.
Yes. That is an international trend, and we're a part of that trend as well.
All right.
And it's driven as much by the labour efficiency as it is by the yield efficiency.
Yeah. And I took from that also that smaller trees also meant less water per tree?
Depending how you managed it, similar amounts of water, but on average I'd say less. Yes, right. But it needs more frequent water because they're much more subject to drought stress. Smaller root area, they're going to go under stress after a relatively short time, whereas a big tree might be drawing on water from a much greater depth and area and can survive a bit of a drought.
Yeah, you did give an example, I've forgotten the name of the actual species you were talking. A lot of apples that you grow that requires far less water than most of the other brands of apples?
Yes, it depends on it depends a little bit on a whole range of things. I mentioned Pink Lady, where it's naturally a large apple, and the market's really for medium size, so we don't have to really push the limit to get the size on it. And they do really require high sugar levels, and we've found if you overwater or put lots of water on, you'll get less sugar levels and your quality won't be so good. And so there is a balance to quality as well as yield. I guess I was putting in those points just to make the point that we need flexibility of water use to actually manage a business now. It's compared to the old days when we put a couple inches on at a time, flooded 100% of the ground. We've actually moved away from that to a much more precise, detailed system that is much harder to manage and more risky, but more rewarding in terms of labour and efficiency and the rest of them.
Yeah, that was a point well made.
Yeah. Great, thank you very much indeed.
That's us. Thank you very much for coming along, Mr. Hopkins and Mr. Hill. Thank you very much.
Thank you very much.
We now have Mr. Ray Knowles, Aspirin Trust.
I guess I'd like to start by saying that we differ, or our submission would differ from previous ones, in that we'd probably be one of the smallest operations that you'll hear from. But as with all the other submitters, we're the extra special one.
Thank you.
So having said that, my name's Ray Knowles, and I'm here representing Aspiron Trust, which is our family trust. And we operate a small horticultural property of 16 hectares on the northern side of the Ngāroa River at Metapiro.
Thank you.
What we do there is we are developing, or have developed, I should say, what is primarily an orchard which is looking to develop nut crops, and specifically chestnuts. And the focus is on coming up with new varieties which will hopefully be commercially viable in the long run. So having said that, if you could just go over some brief history as to where we came from and how we got there. My background has been in horticulture since dot, and some 14 years ago, at that stage we were living in the Waikato, and I'd spent 18 years developing chestnuts back there, only to come to the conclusion that that wasn't really the best area to do it in. So we looked around the country for a new region which we thought would have more potential, and decided to settle on Hawke's Bay, and eventually found a property which we thought would be suitable. And one of the criteria to that property was it had to have a water right, because chestnuts, like any other crop, if you haven't got the right amount of water at the right time, will just be a failure. So having that as a starting point, we set out with a 20-year goal to come up with varieties which we would hope would have a commercial future. Having said that, we had to start basically from scratch to develop these varieties, so there was a long lead time. We've now been at our present site 14 odd years, and over that time we have narrowed the number of potential varieties down to a handful that look like they could have a commercial future. However, that coincides with Plan Change 9, and the ramifications of what that will do to our plans, to be quite honest, are quite diabolical. In fact, they would terminate our effort to do anything useful. And the reason for that is that over the 14 odd years we've been there, although we have exercised our water right constantly over that time, we would probably have only utilised some 10% of what our allocated water was. And the reason for that is because we have just small plantings to test varieties on a small scale to see if they have any potential. There's no point in using our allocated water to its maximum when it was not needed at that stage. However, to go to the next stage, which would be a pilot commercial planting, would require us to use most of our water to its potential maximum. So with Plan Change 9, at least the way I understand it affects us, and it all comes back primarily to that actual and reasonable definition which everybody is struggling with, and I struggle with it even further now after getting my head around the redefining of it. The way I understand that, how that will affect us, is that we would lose 80% of our allocated water volume. And if that comes to pass, that would effectively end our attempt to develop a new crop for Hawke's Bay. One of the reasons why we have spent so much time trying to perfect chestnuts is that we see them as an environmentally friendly crop. It has virtually no input from fertiliser, no input from agrochemicals to any significance. So combined with that, there is a considerable export potential because it's a crop that's well known worldwide but is shrinking in tonnage worldwide because of a whole range of diseases which aren't present in New Zealand. And we can easily grow this crop organically, long-term, minimal impact on the environment, but it does need water. So going through some of the finer detail of what's proposed in Plan Change 9, the way it could impact on us is that I don't really see how the Irika model could help us, because chestnuts don't feature in it whatsoever. So we'd have to come up with some alternative, which at the present time doesn't exist. And I guess the other, or should I say the overreaching effect of proposed Plan Change 9 is how to deal with over-allocation in the whole catchment. And I certainly agree with the sentiment of it. I just disagree with the way it should be implemented as to how to reduce that over-allocation. My proposal would be that to cut all the endless debate about this person and that person and what I should need and what that person should need, would be to just have an across-the-board percentage reduction on the amount of water every consent holder is allowed to take. That simply would be based on the percentage of the allocated volume in the first place. So if the Hawke's Bay Regional Council decides that X amount of water is what's sustainable, and it's a certain amount below what's the current level is, that difference would be simply divided up between the consent holders based on what the percentage of the take is. So yeah, in summary, what I'm looking for is some way to avoid being eliminated. Happy to take any questions.
Thank you, Mr. Knowles.
What's your current, your existing consent? What does that allow you to take?
9 litres a second.
9 litres. And is there an allocation, annual allocation?
Yeah, let's have a look. So the annual allocation is just over 93,500 cubic metres for the year. And currently we're using around about 20,000 cubic metres a year.
So what does 9 litres work out as a daily amount? Do you know off the top of your head?
No, I don't.
And that amount you're currently consented to take, that would be enough to expand your chestnut?
We would hope so.
Was it how many, 16 hectares?
Well, it wouldn't be 16 hectares because some of the property is unsuitable because of contour.
Right, thank you.
Just to follow on from that question, how much of the property did you envisage would be used for chestnuts?
Somewhere between 10 to 14 hectares.
Okay.
Just as a matter of interest, what uses do people put chestnuts to? I mean, you just eat them as chestnuts, or can you do other things with them?
There's a really wide range of uses you can go for. I mean, overseas, a lot of it's processed, simply because it's in its fresh form, it's quite perishable, probably only with a shelf life of, with chilling would be maximum, say, 3 to 6 months. So overseas, a lot of it's processed.
Sorry, that was all I had.
Dr. Cowie?
Where exactly is your farm, Mr. Knowles?
At Metapero, which is on the northern side of the Ngāroa River.
And is your take of water from groundwater?
Surface take. Surface take from a bore, shallow bore.
So it's hydraulically connected to the...
Yeah.
to the stream on your property.
Yes,
Okay,
correct.
thank you.
Was there anything else you wanted to add, Mr. Knowles? We didn't have any more questions.
No, that's it.
Thank you. Hey, thank you very much.
Okay, thanks.
Leslie Wilson, ND and LR Wilson Limited. Welcome. Now, you'll notice we're all on our laptops. That's not because we're focusing on something else. We're bringing up your submission.
That's all right.
Because we're all trying to be paperless. We're trying to
Doesn't
avoid
work.
these things.
I'm about to give you some paper so you lose.
Oh, okay. Oh, we look forward to that. Here we go.
I think there's 5 there.
Thank you. Thank you, Ms. Wilson.
Right, there's just a little bit of background, a few points I'd like to make, and I won't take up much of your time. So we, DN and LR Wilson, have been growing in the Dartmoor Valley, which is on Tutaikuri River, for 34 years, and the Wilson family have been in the valley since 1984. We currently grow 43 hectares on the soil of the boundary of the Tutaikuri River. Initially we grew stone fruit back in the 1980s, diversed into apples and more recently wine grapes. We are shareholders in Mount Erin Fruit Services and Mount Erin Group, which is the marketing arm, and those two organisations the independent growers came together to form a vertically integrated operation, so we grow, pick, pack, market. Two of our children have returned to work in the business. Our son is the orchard manager, and our daughter is now the logistics and inventory manager at Mount Erin Packhouse. And if you know anything about shipping, she's having a whole lot of fun this year. 3 of us now work full-time in the business. We did have other full-time employees, but have chose to move them on. And we employ up to 55 seasonal workers. I'm currently a director on the board of New Zealand Apples and Pears, and the government appointee for Horticulture New Zealand on the Horticultural Export Authority, as well as being former president of the Hawke's Bay Fruit Growers Association and past chair of the Hawke's Bay Fruit Growers Charitable Trust. My husband Desmond is a director of Mount Erin Packhouse and recently retired director of Mount Erin Group. I made a submission on the tank plan change. In summary, the key points of this submission included that we generally support the overall framework to the degree that it reflects a staged approach to improving the management of freshwater resources and tank catchments. We want to note that horticulture is important to the future sustainability of the tank catchments, and some changes are required to ensure that sufficient water is able to provide for this. There is a need to recognise the value of food supply and food security. I note that food security should be a priority. There is no mention of food and fibre production in the objective in Tank 2, or Tank 2 objectives. And we sought that Tank 8 objective be amended to include maintain water quality and quantity for food and fibre production. We note that real change comes from practice, and we support all growers operating in good management practices. Now, these good management practices are continually evolving and changing, and Mr. Hill, the previous speaker, noted that many of the new developments are putting in high-end irrigation systems, as we have done ourselves.
We support the ability for collective approaches to water and nutrient management and seek that this is enabled. We support the acknowledgement of Māori perspectives in the plan change and acknowledge the gap systems that we enact. We need to include more economic impact reporting in Tng. The Tng Economic Assessment Group spent a great deal of time working with parties who collaborated to write the report Economy-Wide Impacts of Proposed Policy Options for Tng Catchments in 2018. I see very little evidence of this in the plan change. I personally want a directive that new houses be equipped with water meters to inform us with the knowledge we need. We can't manage what we don't measure. And further analysis is needed to inform the change to minimum flows and allocation on the Tutaikuri. Tng talked about 2,000 to 2,400 litres per second for the Tutaikuri as a minimum flow. We never spoke of 2,500, but I see that is in there. And I want to draw your attention to, I've given you a one page of a report from 2012. The report is from the Hawke's Bay Regional Council, flow naturalisation for 6 Hawke's Bay river catchments. One of those was the Tutaikuri. And the last paragraph states, it is evident that the volume of abstraction from the Tutaikuri River has a minimal effect on the low to median flow range. The naturalised daily and median flow is 8,591 litres per second, compared to the actual recorded daily median flow of 8,569 litres per second. With the last sentence being the naturalised flow is 3 seconds per litre greater than the actual. I brought this up at Tng, but it wasn't taken any further. So what it is basically saying is that abstraction for irrigation has limited or no effect on the Tutaikuri River low flow rates. It is also, my next point is important that provisions relating to actionable and reasonable do not disadvantage those who are most efficient with water. It also needs to take account for variability in water use over the different phases of production. During Tng, we were asked as a group how we could increase our efficiency by, say, an extra 10%. The pit fruit industry had already done all of that work. So it was very difficult without extra technology to increase efficiencies. Even though I'm not sure we could do 10%. Back to our company. We are Global Gap and GRASP certified. So Global Gap is, they go through all our irrigation records, and GRASP is more for human resources, or looking after our people. We are part of the Sustainable Wine Growing New Zealand program, so that's another audit we go through every year. We are always looking for ways to improve production with regard to sustainability and quality, aligned with our philosophy akin to kaitiakitanga. We are proud of our continual efforts towards improvement, and I'd like to add that I'm in the very early stages of setting up a catchment group in my valley to plant up the streams and waterways which lead into the Tutaikuri River. As a grower, I've been involved with Tng since its inception, that is from 2012, through to its final meeting in 2018. And at that time, as a representative of the Hawke's Bay Fruit Growers Association, like all participants, I put much time and effort into the collaborative process and this plan change, and it was a very worthwhile process. Water security is one of our biggest issues, right up there with labour at the moment, and getting ships. We see threatening, one of the biggest issues we see threatening the sustainability of not only the horticultural sector in the Tng catchments, but to our communities in those catchments. Maintaining or improving the quality and quantity of water that is available to all facets of the community is a primary concern of mine. My own industry has been at the forefront of innovation improving water use, and I am proud of the outcomes our industry has achieved. Irrigation management and efficient use of water. As you will be aware, the pit fruit industry is undergoing a period of rapid change and development. All new blocks, including our own, will have installed in them the latest irrigation systems with efficiencies not seen in the past. Monitoring of soil moisture, targeted irrigation both in space and time, and ongoing research in this field show the industry to be world leaders. We irrigate with conscience both to the environment and to the community. And I think that's me.
Well, thank you very much for your very clear and articulate submission. We may have some questions for you. My question is, I'm just interested in the 43 acres that are currently in
Hectares, yep.
production.
Yep.
What's the ratio between grapes and apples?
So we've got 3 hectares of grapes and the rest is in apples and sugar.
Like it. Thank you.
The grapes are dry land.
Thank you. Any questions?
There's just a couple of questions. You've got a take from groundwater, I assume?
It's deemed a surface take, but it's from a bore, so we're connected to the Tūtaukuri.
So it's effectively a take from the Tūtaukuri surface water.
Yeah, so that's just come in as the part of the whole, basically all the wells up the valley are now surface takes.
So if I'm going up the valley, are you on the left or right side of the road?
On the right side of the road, we've got 2 properties up that valley, and then over the other side, we're on the corner of Swamp Road and Motiapa.
So you would be, what, 300 or 400 metres from the river, your bore?
Yeah, 400, thereabouts.
Okay, thank you. And sorry, how much water are you, what's your current consent,
It's
please?
about 12 to 9 litres per second.
Thank you.
Thank you for giving us this. Just wondering, that this is, the report that's from is dated June 2012. So I'm just wondering whether the amount of abstraction taking place in this particular catchment has increased since that
So
time.
I have been thinking about that, actually. Definitely land use that has changed up there. 2012, there was maize, onions, tomatoes, grapes, apples, and I would say maize, onions, tomatoes, and possibly grapes. The type of irrigation used would not have been as efficient as what we are using now. So in terms of, they were using big guns and that sort of stuff. The water takes, I can't see that there would have been any increase in the number of water takes up there. I think I'd need some help with that, but I think the water take allowances would have been the same. So there's no change in new bores gone in that I know of.
All right, thank you.
Sorry, one other question from me. Are you trickle irrigating your crops, I assume?
So what we've got drip irrigation under all the new blocks. I just add that we doubled in size 3 years ago. So all our new plantings are now drip irrigation. When we bought the first property back in '87, it had what was then a very high-end irrigation system of Dan sprinklers. But what that was it was 100% watering through a sprinkler system, so we were growing grass we didn't need. We immediately changed that in '88 to micro sprinklers, so we're just watering the trees, and we've kept on that line ever since, making sure that we're just watering what needs to grow.
Thank you. That's all our questions. Thanks very much for coming along.
No worries, thank you.
Glenn Riddell.
So he's not coming.
This.
Jeff is next. He should be here shortly, about 7 minutes.
Oh, okay. So we've got next Twyford Water, Jeff Van Beek, who's going to be here shortly. Oh, what I'm saying is we've caught up to our timetable. We're no longer running late, so we're just waiting for Jeff Van Beek. He's going to be here shortly.
We're about 10 minutes ahead. I don't want to say that too loud.
Good afternoon, Mr Van Beek.
Good afternoon.
We're just a little bit ahead of time, but if you're ready to present, we're happy to hear from you.
I'll give it a go.
Thank you.
Okay. Greetings. My name is Jerif Van Beek, and I don't expect you to pronounce it properly. Most Te words I have trouble with. And I represent the Twyford Waters user group, of which I'm the chair. Also, greetings to staff of Hawkesbury Regional Council and those in the gallery. As a current Hawkesbury Regional Councillor and past member of the Tng stakeholder group, of which I only missed one meeting in 6 long years, and Bruce Mackay, who you heard from this morning, continues to scold me for missing that one meeting in those 6 long years. During those years, I learned to walk in other people's moccasins, like those of the Mangaroa Marae, Fishing Game, and Nio, who's here present. It was a really amazing learning experience for me. By the way, I won't be referring to my written submission. I'm predominantly here to speak to you about an important part of the Tng process. Regarding learning to walk in other people's moccasins, that may not relate to Dr. Anthony Coles, but I will explain that later. I thank you for allowing me to take up 5 minutes of your precious time. I aim to attend as many of the Mangaroa Marae hearings presentations as council duties would allow me. To cover the broad topics of the Tng plan change in the short time allotted to me would not do our submission justice. Hence, I'm to provide you with some understanding on how Twyford Water was able to achieve what we feel is an important part of the Tng solution. In a comment on the redirection of 20 cubic metres per day down to 8 cubic metres per day, and a conclusion at the final. Twyford Global Consent. Our interest is in equal water for all Hiratonga Plains, and especially those areas that are currently without water allocation. I need to put that and state that right up front, including environment, urban, rural, and industrial. Our catchphrase was at the time, trees, plants, stock, and wildlife can do with less water, but not without water. Even Fish and Game approved of our stance. The background. The Twyford unconfined and semi-confined hearings in 2010 resulted in large parcels of land being without or almost without viable irrigation water. This resulted in some serious issues for our region. Real estate agents started to shun Twyford due to the unreliable nature of water. Land values started to drop. Parcels of land would become pony paddocks. Nothing against ponies. Reverse sensitivity would make it very difficult to operate a horticulture business with the amount of lifestylers eyeing up cheap land. Personally, I was one of the most affected and lost more than half of the irrigation volume I thought I had before going through the reconsenting process. The reason for this dramatic occurrence was due to the overzealous Hawkesbury regional staff, not the people that are here by the way, who were given the direction to claw back water wherever they could due to a perceived over-allocation. This was based on consented, not actual allocation. This had been going on for 5 years prior to the hearings. I will not bore you with the details on how this eventuated and what tactics they applied. But it was not only due to staff actions, irrigators also had applied poor practice in their administration. In essence, irrigators had never been challenged on their consented water volumes, and water use had never been measured before. Compulsory telemetry metering was initially seen as intrusive, but has been incredibly important for finding the Twyford Water Global Consent solution. And I want to make that point really clear, that generally telemetry metering was a real issue for primary producers. They felt that it was intrusive in their business, and why would they need to provide all this information? From a Twyford irrigator perspective, it's the outcome. That's what you need to do. You need to measure. If you don't measure, you can't manage. And somewhat, I was disappointed this morning with one of the submitters actually not even knowing what their volume of water was, how long they could use that water for, and what their their link was to some of the water bodies. To me, it is like driving to Auckland and not actually even checking your petrol tank, whether there's enough petrol in there. So coming back to the issue we had in Twyford. Leasing out properties to neighbours and corporates was the norm of the day, which lacked ownership oversight of consents. In essence, asleep at the wheel comes to mind. A few peak bodies, so-called specialists, told the consent holders that it was all in hand. I still remember one of those well-meaning folk turning around to me in the gallery on the first day of the hearings and lamenting that we had a lemon by the tail. I was not sure what he meant at the time, but I knew from what I was hearing during the deliberations that it was not good. A plus from the hearings was that by enhancing the riparian corridor along the stream, we were able to extend the individual consent duration by 6 years. Consent holders agreed to pay $11 per hectare each year, which we use for annual riparian planting and maintaining of the riparian stream. Fantastic outcome. A total of 22 kilometres by 2025 is our aim, and by that time we would have the whole stream planted up where we're able to. 2011 to 2012 season was a very wet season, which did not help to feel the full effect of the hearings outcome. But then came the 2012-13 drought season. Never let a good crisis go to waste, so get an outcome you desire. COVID-19 is one of these. With telemetry on every irrigation well and the Raupari and Ngārororo going soon on ban, there was nowhere to hide but to face the consequences. So what I'm trying to say there was, prior to that, there were no meters, bans were put in place, irrigators weren't even aware there were bans on, continued to irrigate. Poor behaviour from a primary industry behalf, and I put my hand up for that. Hawkesbury councillors and the CEO did not want to assist in finding solutions, since they had their sights on their beloved Tanafa Dam, and hopefully I have not offended anyone. We likened this to planning a summer house while the old glorious homestead is burning down behind you. So we had Heratonga Plains, well-developed production systems that were without water, and they were looking at planning a dam for the future, okay? And our beloved peak body miraculously now only would deal with national issues, not backwaters like Hawke's Bay. What I'm trying to say there is we're on our own. A grower meeting was called to see if we could find our own solutions. Twyford Water was incorporated, and we had 100% membership of those who held consents in Twyford. That's how serious this situation was. By the time we called the second meeting to meet with Hawkesbury regional staff, the Ngārororo was already 10 days on ban, and the Raupari was about to go below the 300 litres a second minimum flow. At this meeting, we found out that the plan allowed for water to be augmented into a water body as long as we met certain criteria. The criteria were as follows. The augmented water had to be cooler than the receiving water body. The augmented water had to be higher in oxygen than the receiving water body. The augmented water was not allowed to be additional water, but consented water only. So it had to come from our consents rather than additional water pulled out of the aquifer. The majority of the water body had to benefit from the augmentation, so we couldn't just put it in just prior to the measuring device that the Hawkesbury Region Council uses to measure the flow of the Raupari, but we actually had to make sure that the whole of the tributary was benefiting. The stream bed was not to be scoured out or damaged by the augmentation flow. Council staff allowed Twyford Water to run some tests, and very soon we had 3 pumps pumping irrigation water through an oxidation plant and truck tarps to stop erosion. As you can hear from what I'm saying, it was pretty rudimentary to start with. It soon became apparent that we needed to develop a global consent to be able to access enough augmentation water without running irrigators out of water due to them sacrificing their consented volume for the good of the Raupari stream. Our planner worked with council staff to draft a global consent which was approved in quick, smart fashion. This was first of its kind. As long as we did not go over the total consented volume in a 28-day period, and each consent did not exceed the litres per second pumped, we would be okay. We knew it could work due to our mixed cropping nature of Twyford. So Twyford is made up of grapes, predominantly apples, summer fruit, squash, onions, beetroot, you name it, and there is some grazing as well. Our consultants calculated if we predominantly dairy, we would not be able to irrigate on demand. We developed a web-based dashboard, WaterSense, for management and consent reporting purposes. Outcomes of the global consent and augmentation. By the end of the very dry season of 2012-2013, we only used a combined total of 47.9% of our total allocated global consent. This included the properties who had no access to water but which were allowed to join the global consent. In effect, we are able to transfer irrigation water across our individual consent boundaries without having to encounter red consenting tape, experience loss of time and opportunities, and incur unnecessary cost. We've seen unprecedented cooperation of members to comply with Twyford water requirements. The Raupery has never since 2013 reached the low flow due to our augmentation. Apart from Council's failure to keep the flow measuring device operating, and Dr. Brent, you made a point about that before, you can't always trust telemetry. The last two severe drought seasons have seen very few days that we've had to augment, and this is really puzzling us. One of the key outcomes of providing reliable irrigation water is often overlooked. Having low flows or bans, which are debilitating do result in panic and inefficient irrigation use. Toilet paper comes to mind. So once you create a shortage, or even a shortage is someone's mind, people will go to the supermarket and fill up their trolleys with toilet paper. Irrigation water is no different. If a ban is imminent, and the pumps will be working overtime to fill up the soil profile, thinking that the soil profile is a water storage vessel. This is the wrong application of a finite resource of a great value. In Twyford, we've seen very efficient use of water, even under very extreme conditions. We only have been in this situation only once, and I'll give you an example. In the 2012-2013 season, we struggled to keep the minimum flow of the Raupery above 300 litres a second. We had 3 pumps running. This is how severe the drought was on the plains at the time. So I asked the members by email if there was a spare irrigation pump that I could use to increase the augmented volume. To our surprise, the Raupery flow increased overnight, and we even had the luxury to turn one of our pumps off for the remainder of the season. So what this really meant was, when I asked, can I please have another pump? I can't keep up. When the following morning or that night, when they're standing next to the switch to turn on the irrigation, they decided, actually, I can do without. I know that Twyford Irrigator Group is actually struggling to keep the flow up, so therefore I won't irrigate. And so we have in our consent documents, and as a member MOU, that if we as an executive deem that we're getting too close and cannot keep up with the augmentation, that we reduce to 75% to 50% to less water use. So we actually can dictate to our members how much water they can use, depending on the situation. However, we haven't been there yet. Irrigators decided that less water was better than no water. The Raupery is in good health and is the cleanest lowland stream that flows amidst pasture and horticultural land on the Hiratonga Plains. Our plan is to enhance this by planting up to 22 kilometres of riparian strips along the stream, as mentioned before. The future. Stream flow enhancement through augmentation, if done appropriately, is the answer for Hiratonga Plains aquifer, rivers, streams, and environment. And maybe I can turn that around in order. They're not there in a specific order. Climate change is upon us. Peaks and troughs will become more prominent. Augmentation should, in theory, not come from the aquifer. My view is that this should come indirectly from high flow storage, and by releasing stored water into the environment, which then will end up in the aquifers and then subsequently to be used for augmentation if required. Releases into the environment via the aquifer, streams, rivers is beneficial for the environment, without having to stress the same aquifers, rivers, streams due to irrigation use. Twyford Water now has a fully functioning automatic augmentation device, which in the future will be able to release augmentation water that follows the diurnal natural flow of the stream. With other words, we aim to not flatline the flow. We actually want to work with the stream itself. Just a quick comment on the 20 cubic metres down to the 8 cubic metres. It is such a small reduction in the overall scheme, but is absolutely vital for small landowners who depend on this water to provide for stock and rootstock survival. A mature cattle beast drinks up to 70 litres per water a day, 285 heads versus 114 head of cattle. 20 cubic metres over an average of, say, 8 hectares, 15,000 trees, is 1.5 litres of stock survival water per day, enough to keep that stock, rootstock alive. It would not be enough, as Mr. Apple pointed out, to have an economic business. But when we get into these really dry periods, maybe 1 in 10, maybe 1 in 12 years, at least we can keep our rootstock alive. The concept of John Bostock water, you may have heard the concept or the term before. What this means is people who own a lot of water. During the tank stakeholder process, Dr. Anthony Cole was asked to do a socio-economic report on the influence of water on the Hawke's Bay Society as a whole. When I was asked to meet with Dr. Cole at the Raupo augmentation site to explain the process of augmentation, I was a bit taken back by the doctor when exiting his car he did not wear any shoes, and hence I did not have the pleasure of having to walk in his moccasins. Dr. Cole spent a good morning talking about the Twyford situation. This discussion did not just cover water, but labour also became a point of interest for Dr. Cole. At the time, I was contracted by Horticulture New Zealand as a national coordinator for seasonal labour, as well as being a local cherry grower, a position I held for 14 years, which involved developing and establishing the RSC scheme with government officials. Dr. Cole even took time to have a meal with a group of Pacific RSC workers to come to understand their place in the Hawke's Bay community. He asked me to arrange the group, but I was not required to be present, and I got the point. He really wanted to have a korero with them. I got the point. You are aware of the RSC scheme, I hope. I don't need to go into detail and explain it to you what it really means for our primary industry. The main point of Dr. Cole's report was that primary sector water was intrinsically linked to the well-being of areas like Flaxmere, Camberley, Maranui, Omahu, Bridgebar, etc., more so than the suburbs of Havelock, North or Taradale. Every permanent and seasonal job at John Bostock's, Turners and Growers, Mr. Apple, Appleton Farms or Riverside Cherries, my orchard, for that matter, is linked to irrigation water. In Hawke's Bay, growing a commercial crop can only be grown economically with the addition of water, full stop. That's how horticulture on the Heretaunga Plains works. I believe if God would be asked to create a perfect place to grow apples, summer fruit, etc., he would create the Heretaunga Plains all over. A temperate climate, plenty of the best water in the world, alluvial soils, sea climate influences, and we have the most amazing people. Conclusion. I wish you all the wisdom in your deliberations. And I ask you to remember the people who rely on this amazing resource. And I'm not talking about landowners. However, we have become more efficient and do all we can do to improve the environment. I believe the Hawkesbury Region Council is on the right track to put the emphasis on the environment fair and square. One of the reasons I am there as a councillor. Right tree, right place, etc. Kia ora.
Thank you very much. I like to pride myself in pronouncing people's names properly. So could you pronounce your name again to me one more time?
I can even give you some help with that. Jareth, Sheriff for the J.
Jareth
And Van Bake, like an oven.
Beek.
Jareth Van Bake.
Jareth Van Beek.
Very good.
Is that okay? Thank you. We're going to ask for any questions.
Thank you, Mr Van Beek. I've been interested in the augmentation scheme you've got going there, and in particular the logistics behind that in terms of how has it worked in terms of the mechanics of when it's decided to that the stream needs augmentation. You know, who makes those decisions, and I guess with your group, there's obviously a reasonable degree of administrative burden, if you like, in running that, and I'd be interested in your thoughts on how, is this a good template that could be used or copied elsewhere in the tank catchments?
Yeah, and I believe not only in the tank, I've spoken around New Zealand 6 to 7 times to irrigator groups who'd like to find out what we've done. So we work on an enormous amount of trust. So we have a Schedule 1 where every grower who's decided to become a member of Twyford Water, they've actually given over their consent into the global consent. So we have one consent which makes up all the consents underneath it. But they belong, and that's quite amazing, they belong to Twyford Water. And in our rules, we have that the person who puts the water in is the only one who can ask to take it out. No one else can actually create that move between the global consent and back to their own consent. We don't have all growers in Twyford belong to Twyford Water. And the reason for that is we have, for instance, Turners and Growers. They are an overseas owned cooperative, and they find it very difficult to explain to a German owner that they need to give their water away to a group of Twyford hacks. And I get that, it's not a problem. But as I've explained to you, the water that actually is in the Twyford Global Consent, plus we have quite a number of growers who have no water at all. They also are part of the consent. So they actually can use that water in the global consent. All the consent is concerned about is that we don't go over the total limit on a 7-day basis, on a 28-day basis, and on an annual basis. Plus, each consent, every grower, every well on their consent, they have a litres per second that they can abstract. They cannot exceed that either. So that is in itself quite enough restriction for us to make sure that we don't go over our limit. We do have water sense, so we can see every consent holder when they irrigate, how much water they have used. So if a particular grower goes over their consent, we actually go and have a chat with them. Because we believe on our numbers, 47.9% of our total water was only used during the 12-13 drought, and that was the fiercest drought. Last year and this year haven't even come close to it from a Hiratonga Plains perspective. It puzzles us why the Rauperi actually has yielded as much water as it has done. And we've looked into all the facets of it. We have asked the council to check their metering device, and we've asked to actually cut the weeds more often than not, just to make sure we actually get flow through, because it doesn't seem quite right, but it is what it is. We cannot actually really find the answer. So we can see on an individual basis what growers are using through telemetry, which is fantastic. And it's not always correct, but we, under the consent, actually have agreed that we actually would do our own verification of water meters. So we have a summer student that works for us every season, and they actually go around all the meters, take a photograph, time and date, come back 2 weeks later and actually take another photograph and then work out through WaterSense the data that we've given to the council is actually correct with the water meter. So that's what we've taken upon ourselves. For us, it's actually very important that we are accurate in our data. Otherwise, we can't manage our resource.
And in terms of that resourcing, do you just have someone, like delegated someone who will check the flows in the stream and determine whether augmentation is required?
We've got a board of 3, an executive of 3, which I'm the chair of, and we have 2 of us keep eyes on it. Our augmentation device has got a accentuator on it that we can actually access by Bluetooth. So I can be in New York and I can turn the augmentation device on if I can see that we're getting close to the 300 litres a second. So we can dial it up as we would like.
All right, thank you.
Yes, thank you very much for your presentation. Just several questions. How many in the water group?
We've got 60 consents in total. We've got bar 1 that is not a member of our of Twyford Water. It's an overseas owner that we haven't been able to contact. Everybody else is a member. But out of that, we have got about 65% of the water that actually has been moved into our global consent. So we've got 99% of growers are members of Twyford Water. They pay an annual fee on a per hectare basis to Twyford Water. We contemplated whether we would actually have a per hectare fee, a membership fee, or whether we would apply for a water use fee, amount of water used. And we felt that the value of land is what really drives investment within the industry. And we felt that if you have valuable land, you actually are better, it's easier to how do I explain it? It would be easier to verify why you would have to pay $35 or $85 a hectare. We already pay $11 via our rates to the Hawke's Region Council to do our riparian planting, and we do that ourselves. So our friendly bank. But we have $85 in the past we've actually paid. And for that money, for instance, we've developed the WaterSense app, the dashboard. We've put our own well in. It's gone 65 metres deep, put our augmentation plant on it, and that's all paid for now. So we've actually got some more plans to put additional augmentation places on the tributaries.
And it's fair to say, I understand from your submission, that part of the reason this works is you don't have the same demand for water among all the users all the time. So rather than being a monoculture, if you like apples, there's a diverse range of crops, vegetables, etc. grown, and so the demand isn't all at one, or the demand doesn't all peak at the same time. Is that a fair comment?
Absolutely. So onions is a very water-hungry crop, but it actually is in the first part of our season. When we start to really put growth on apples and stone fruit, that's the later part of the season. And also root crops at that stage need to have water to maintain and actually go through a winter period and actually set themselves up, as you possibly picked up from the Mr. Apple submission. So because we have different times of irrigation needs, we're able to actually share this water. And 28 days is actually, in a growing season, actually quite a short period. So it works really well for us. I often get the question when I travel around the country and talk about Twyford Water is, yeah, but what will happen if the pressure goes on and your allocation is 47.9%? What will happen? I believe that we have been able to create trust amongst the members that there will be water. And as I said, and our catch cry is, we can do with less water, but we can't do without water.
And I think we had some concerns expressed by Mr. Hill that correct me if I'm wrong, Rule 11, which talks about global consents, may not cover his situation. Do you share that concern at all? It seemed, when I read the rule, it seemed to me that it specifically allowed for the sort of situation that he explained and for the situation you've explained. Is that your impression?
To me, it's not. If you, because that's Mr. Hill used to be my employer. I used to work for Mr. Apple as well, so no disrespect, but I think it's not understanding how these global consents work. If you would ask any of our members, we've got Turners and Growers, we've got John Bostock, we've got Apatoos, we've got Bailey Produce, we've got some very large growers in our group, and they all supported 100%. They understand, and they would like to see similar global consents in other areas where they're growing as well. And Mr. Apple is part of a member, but we actually have a bit of trouble with them being on the exchange, on the local exchange, to actually put their water into our bucket. So they benefit from it and they pay us levies, but you know, putting water in the bucket is a bit of a bridge too far for them.
Okay, thank you.
Interesting.
How and why do people join Twyford Water?
Once the ban comes on, in theory, they should stop irrigating. In theory. But they know at present time that we will actually keep the minimum flow up, so therefore they can continue to irrigate. So in theory, they actually don't have to join. They have to be a member. But they do it because they feel that actually from a community perspective, they are obliged to do so. So all those who have not joined have got very good reasons, and that could be because they're part of the stock exchange, because they're a listed company, or they're overseas owned, and I get those reasons. Most individual, about all individual growers who can make that decision while they're sitting at their kitchen table having breakfast, they're all part of this because they understand how it works. But it's also the safety that we have got in our MOU with the growers, that they're at any one time, they are the ones who are in control of their own water and can take their own water out. So it's once again, it's trusting those who actually have developed the global consent as well. I was very fortunate to have found a solution around labour for this group of people through the RSE scheme. And so I had been in front of this group of people for a long time, and they could see what I promised them actually came to fruition. And I think I had a second time with water and they trusted me again. And fortunately it has worked with the help of Halter Region Council staff.
So are you always looking to build your membership?
We would like to have as much water in the global consent as possible, because it also means that we actually can take on more members who don't have water, so we actually can share.
Do you have any Māori members?
The Apatoos have got a very large parcel of land and they're part of our membership, okay. Yes.
Yeah, that's the Apatoo farm.
Yes, that's right.
All right. Just had one, the point you make about you're being able to manage every member of your group vis-a-vis the amount of water that they take and use. Is that the only management regime that they have? Is there anything in addition to how you manage them?
Those who are within theory, not. So if they actually go beyond their bounds of their individual consents, which are part of our Schedule 1, we have the opportunity to actually remove them from our membership. Then they actually would become under the wrath of the Hawke's Region Council staff and compliance there. So we've had one instance of a grower who, unbeknown to him, went way over his water use. And once again, if you don't measure, you can't manage. And we picked it up through our water sense dashboard, went to see him, found out what the problem was. He had a burst pipe very close to his drainage system, and he was never aware that he was pumping water 24/7. So we're able to stop that. If a grower would have irrigated to his fullest extent and over irrigated, we then would talk to that grower and say, well, we have an issue. If there's no fault in the system, but the way they actually operate the system and how they irrigate, we would actually say, well, you've got a minimum amount or maximum amount of water, 32 millimetres per week, and you are going over that actually is not in accord with our MOU with you. You've got a certain amount of time to rectify that. If not, we'll actually remove you from our membership. We will remove your water out of our Schedule 1, and you're now actually under the you will become the compliance of the Hawkesbury Regional Council. We have not been in that situation yet, but whenever we have spoken to growers who actually have over-irrigated, the problem was very quickly rectified.
So the way the process works, I mean, individuals get their own permits, right? And then
Consents, yep.
And then they contribute to the bigger pool.
Global consent, yes.
Yeah, but they maintain their 10 cents worth or whatever it is. I mean,
they maintain the ownership of that water in name. So it sits in the Schedule 1, and their name is behind that particular consent. And they have obligations as to how they actually treat the water that effectively is actually lent to the global consent and then reused again for their purposes. So if we have Mr. Apple, we've got about 10 different orchards in Twyford that belong to Mr. Apple. In Mr. Apple's situation, they can actually move that water around amongst themselves, so to speak. For instance, if one of the 10 had no water whatsoever, they now can put that water into the global consent. They more or less can go and borrow the water from further down. It's the same water, of course. But
good. Thanks very much.
Thank you, Mr. Van Beek. Really appreciate you come through, and it was very interesting to hear more details about how it worked. It certainly wasn't in your original submission, but we've got lots of detail in terms of what you're looking for in terms of relief in there, so thank you very much.
good. Thank you for your time.
We've got a lunch break now, and we'll be back at 2 o'clock, and we'll have Hope Monitoring, Stephen Randall, and Colin Campbell, and we're going to have Browrig Agriculture. Lara Blomfield's going to come in and fill that 240 spot. Great. We'll see everyone at 2 o'clock. Thank you.